Please, Your Lordship. Your Lordship, right after the motion, if the item number 3, PL 1 of 2022, if it is taken up,
Okay.
because serial number 2, item number 2 may take time. So if the PL is allowed to be taken up, item number 3.
Okay.
Number 1.
May I please, Lordship.
Yes.
This is a habeas corpus petition against the detention order under section 3+1 of Peace and DPS. The detention order is at page 39. Annexure D, page 39. The detention order was passed while the detained was on bail. 6 months after his arrest and after the 6 months from his arrest, and proposal was formulated 3 months after his arrest, and it took 3 months for the detention authority to pass the detention order.
Then what happened? This 3 months is already expired.
Your Lordship.
It was for a period of 3 months.
Yeah,
May,
thereafter
June.
it was extended.
Which order?
It's in page 64. It was extended for another period of 3 months with effect from 16 August 2024. Annexure I, page 64.
Prevention of illicit traffic act. Prevention of illicit. Nine F. Do you have a copy of the act? NDPS Act. It is in the NDPS Act.
Your Lordship, Peace and DPS.
One more. Let's see. No, I have suddenly noticed whether this is correct or not. I don't know. Page 124. What is the period of detention otherwise provided for?
Yeah, your lordship.
What is the period of detention provided for? What is the maximum period of detention?
For 1 year, thereafter it can
Where
be
is
extended
that?
to.
Where is that? Which section? You're detained. Section 11.
Uh, Your Honor, section 11.
I have seen. Mr. Thibapom,
Yes, my lord.
page 39 is the initial order
Yes,
of detention
yes,
for an initial period of 3 months.
yes,
That is 13 May.
yes.
So 13 May, if it is counted from 13 May, when is the date of expiry of 3 months?
13 May.
May, June, July,
July.
August.
August, yes.
13 August.
August 13.
13 August.
Yes.
Come to page 64.
Confirmation order.
14th August.
Yes.
And that extension is from 16th August. One thing which has already expired, how can it be extended? Something which is in currency that can be extended. But one thing which has already expired, period expired, whether it can be extended with retrospective effect. I don't think that is the meaning of extension. And it is in bold letter, page 64. From 16th August to 15th November.
November.
Though it is not urged by the learned counsel for the petition.
Yes. So, my lord, let the notice be issued, my lord.
Heard Mr.
V. Theo.
Learned counsel for the petitioner. And Mr. Thibapom.
On behalf of respondent number 1 and 3.
Miss Learned Senior Government Advocate,
Senior government.
Senior Government Advocate for the respondent number 1 and 3, and who
Yes.
represents the in this writ petition. The petitioner has challenged entirely challenged an order of detention dated 13/5/2024 within bracket Annex D, passed in exercise of powers conferred by subsection 1 of section 3 of the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act within bracket PIT NDPS Act, 1988, whereby the petitioner had been detained for an initial period of 3 months. Full stop. The petitioner has also assailed an order of rejection dated 11/7/2024 and an order of confirmation dated 14/8/2024, whereby order of confirmation dated so and so annexure I, whereby the Chief Secretary to the Government of Assam, Nagaland, has extended the period of detention for another 3 months, with effect from 16/8/2024 till 15/11/2024. In exercise of powers under Clause F of Section 9 of PIT and DPS Act 1988. After, where is the advisory board? Order? Okay, post on. The petition has challenged his order of detention and the order of extension of detention on various grounds. The matter would require consideration. Issue notice returnable on
My lord, after 2 weeks.
23 October
Okay.
23/10/2024. As Mr. Thibapong, so and so has appeared and accepted notice on behalf of the respondent number 1 and 3, issuance of formal notice to the said respondents stands dispensed with. However, learned counsel for the petitioner shall furnish requisite number of extra copies of the petition along with annexes to Mr. Thibapong within 2 working days from today. The petitioner shall furnish serve a copy of the writ petition along with annexer to the learned Central Government Council for the purpose of service of notice upon the respondent number 2 within 2 of Mr. and Mr. So and so. That involved hard 3 names. Then as Mr. Inguli. That involved. Yeah, then. And the peer accepted notice on behalf of the respondent number 2. So formal notice to the student. So 2 working days. Raise the case on 23/10/2024.
Much obliged.
For admission, item number 3.
Please, Lordships, my senior Mr. Ejimomi, he tenders his apology because he is not being able to come today. My lord, he has to, he's out of station for his son's educational purposes, my lord. So he tenders his apologies for not being able to be present today here in court, my lord.
Yes. What was the issue?
Lordship, may kindly peruse the order dated 4/9/2024, Lordship. Direction was issued to the NHDCL as well as contractor to deliberate and come up with a solution, Lordship. May I read the Lordships? But Mr. So-and-so, learned amicus, Mr. So-and-so, learned counsel for NHIDCL, and Mr. So-and-so, learned additional AG, Nagaland for the respondent number so-and-so, and Mr. So-and-so, learned counsel for respondent number 9, contractor, and Mr. So-and-so for respondent number 10. We have perused the affidavit dated 4/9/2024, filed by the respondent 2 and 8. Paragraph 7 of the affidavit reads as follows. 7. For execution of the required maintenance and safety works by a third party. This works will be carried out at the risk and cost of respondent number 9, that is the contractor, Lordships, as per the recommendations of the authorities engineer. The decision to invoke the risks and cost clause is not taken lightly, but it is deemed necessary to prevent further deterioration of the highway and to ensure that it meets the required safety. Lordship.
Mao means border.
Bordering, yes, Lordship. State of Manipur, Lordship. Lordship. The first affidavit I filed is on 18/9/2024, Lordship, by respondent number 2 and 8, Lordship.
Respondent number 2 and 8.
Lordship. 18/9/2024.
I give the affidavit of 2 and 8 of 4/9/2024 also. Mr. Jamir, you come to the first affidavit 49/2024.
49.
2024,
Lordship.
where from the paragraph 7 was extracted.
Lordship.
Come to page 108. Is this the NIT which has been floated now? 108.
And it was floated on 7th.
Come to page
Lordship.
108. Is this not mentioned in the affidavit? Copy of the letter. Copy of the letter.
Lordship, may kindly come
Uh-huh.
to page 112, Lordship. 11.
No, this is not part of the
NIT.
pleading.
Yes,
No, where from? Come to paragraph 6.
Lordship. Lordship.
The copy of the NIT D1. D1. Where is D1?
Paragraph 3, Lordship.
Where is that annexer D1?
Page 6, 7. 7.
Page 91 perhaps. There is no date. Is it published or not published?
Lordship, it was published on 28/8/2024.
20.
8/8/2024. But you'll find all the details of the detention process on page 92, Lordship. And there's a table.
8. It brings. Okay. So after publication of this NIT, whether tenders were received,
Lordship, yes. We have to open the detention.
bids were received or not? Huh? Because the order is not to open the tender.
Yes, Lord.
It is not, order is not that not to receive the tender. Please clarify. Not to open the tender is one thing and not to receive the tender is another thing.
Lord.
There is a schedule in page 92
Yes, Lord.
that last date of receipt of pre-bid queries, date of pre-bid meeting, last date of submission of tender 18/9/2024. Now, what is your exact instruction? Okay, yes, please come over. Because the order is not to open the tender. It is, the order is not to receive the tender, it is not there. So you extended the, okay. It is over or what? 7th? 7th of this month. What was the notice given to the contractor? Response number 9. Risk and costs notice. The contract work of execution of the national highway was not taken over from him. The contract work of execution or construction of the national highway was not taken over from him. No. It is only the maintenance part. Yes.
This can post in a post itself.
Hmm.
Then we have plotted our own post that get the public this statement. So that next tender was done for that purpose.
So he is constructing the national highway otherwise. Then why it is small measures? No, about the construction work, was it complete? He was the only contractor who has given the entire work.
Only portion was the only one.
Yes. What is the stretch?
That is 25 kilometers.
25 kilometer. How much, as per the original contract, what was the completion period?
Since it is already over, sir.
How much percentage?
74% they have completed, sir.
Hmm.
But sir, many places, this is already failure has happened, sir. Failure of construction as well. So real progress is less, sir, but they have done 70%. They have related us.
Hmm?
Sent the ministry.
Hmm.
The chip CD, affidavit of 24 September 2023. Filed by the NHIDC.
If it meets 20?
24 September 2024. Paragraph 2 and 3.
Who is the contractor? You have filed an affidavit. Your respond number?
Right, Lordship, I filed an affidavit this morning also. Conversely, your lordships, apparently there is an understanding between the contractor as well as the respondent number 2 and 8. And I was also informed personally by the executive director who is standing before his own court this morning that the claim to put the work, the contract to issue the NIT at the risk and cost of the contractor is understandably it is set aside. And they want to go ahead with the fresh contractor. But that submission is not made before your lordships. I was expecting that because I'm not averse to that. My lords, as far as our contract is concerned, it is deemed terminated with effect from 18/9/2024, my lords. And presently also by the affidavit dated 24th September 2024, filed by the respondent number 2 and 8, since a specific pleading was made that we should be allowed to maintain the existing road. So we allowed our men force to continue with the.
No, where is the specific termination of contract?
Your lordship,
Where is that letter?
the Lord may kindly have a look at my affidavit filed this morning. Lordship, the letter dated 25/9/2024.
Annex, sir.
Page 12, Annexure B, page 12. No, paragraph 5 at page 13. That pursuant to the termination notice issued by the EPC contractor on 18/9/2024, the contract between the parties, that is NHIDCL and MS Fortune Group, stands terminated with effect from 18/9/2024.
You read once again, pursuant to a termination notice issued by the EPC contractor. It is you.
Yes, your lordship. So we issued a termination notice and they have accepted. And it is deemed terminated with effect from 18/9/2024. The lordship, few days back, since they filed the affidavit on 24/9/2024 stating that road needs to be maintained by us. So we send our men force to maintain the road. Unfortunately, an FIR was also lodged against us just because we wanted to fill the potholes and make the road liable for the commuters, your lordships.
No, where is the termination clause
My lords,
under which you have issued the termination notice?
as per the clause 23. My lords, I may take the lordship to my affidavit.
No, where is your termination notice? Is it part of any pleading? Your
Yes,
termination notice
Yes,
dated.
your lordship, in the last affidavit, we have produced, we have annexed our letter, your lordship. In the last affidavit filed on 24/9/2024. 24/9/2024, your lordship.
Only that one.
The annexure G, page 33, my lord.
Affidavit dated
Affidavit dated 24/9/2024, my lords.
of
Respondent number 9. And 23 minutes. Very nice. Page 33, annexure G.
So what does the termination clause says? On service of a termination notice, it stands terminated or what?
No, your lordship, it has to be, it has to be accepted by the authority and the NHRDC has already accepted. They already accepted.
Yes, yes. Where is the termination clause otherwise?
Your lordship, I have annexed in my affidavits filed this morning.
Termination clause,
Yes, your lordship.
where is that?
My lords, page 22, starting from page 22, my lord. Annexure F. My lord, the relevant paragraph 23(2).
Authority fails to cure such default within a cure period of 90 days. So it does not come into effect as soon as the termination notice is served. That is my understanding.
Your lordship, but it also depends on,
That is a matter of
Yes,
dispute
Your
whether
yes,
they have defaulted or not, or you have defaulted. We are not going into that aspect.
my lord, your lordship.
Presently, the matter of the moment is maintenance of the that
Yes, Your
stretch, limited stretch of the highway,
Yes, your lordship.
for which they have floated a tender.
Yes, your lordship. So, your lordship, the only conflict of interest in the floating the NIT was that it would be at the risk and cost of the contractor, and that was a dispute.
That
but-
is not a matter of PIL.
Yes, your lordship.
Absolutely not.
I have treated that in my.
Absolutely not.
my-
This is a part of dispute resolution process. If
Yes,
there
ma'am.
is arbitration, conciliation, all these risk and clause, you argue there,
Yes, my lord.
not a matter to be argued here.
Yes, your lordship. I have made that specific meeting, your lordship, this morning, but since they would not want to insist on that, my lord, and our contract is terminated. So we have no issue on the NIT which they are floating now, my lords.
So this is the main. This is the main. Presently, we will be concerned with that. And so that time around, negotiation failed. Right. Now, with regard to the interest of the public, I think we should be clear that interest we should self-possible to handle it. That is actually we are not concerned. These are purely commercial issues. That will be a matter of verification. We are not, we are on the road. We suffer. We are concerned with freedom. We suffer because we are not suffering. We can make our dispute before either the investigation or the arbitration for the arbitration. We are not suffering. There had to be whether there is termination, fait accompli or not, these are not to be gone into in the PL. Matter of the moment is maintenance of that particular work. And as per the affidavit of the NHIDCL, you seem to have abandoned.
That was their affidavit.
And whatever, but you are surviving only on the basis of that interim order dated 4/9/2024. Had it been not there, the tender process would have been completed. Because there was no individual challenge to the NIT by the contractor. And that is cannot be a part of the PL also. It is up to the contractor. But so far as the maintenance work is concerned, they have floated an NIT. Tenders have been invited because of the 4/9/2024 order. The matter has been stalled, giving opportunity to the contractor and to the NHIDCL to trace out the difference and to find an amicable solution, but that process failed.
And
We are not concerned with NHIC vis-a-vis contractor. We are concerned with the public at large.
Madam.
Am I clear?
Yes, Your Lordship. Yes, Your Lordship.
So, having regard to the larger interest of the public, we feel at this stage that the tender process should go ahead and should be completed within a definite timeline. And thereafter, the contractor, whoever is entrusted, should complete the work as per the time schedule. That is, we are concerned with. We are not concerned with whether this termination notice has been affected or not,
Yes.
correctly affected, because 90 days cure period, all these are there. We're not going into
Yes,
that aspect. Yes.
I have a respectful submission, Lord. Even Lord, this honorable court, there's a decision to go ahead with the NIT, Lord. For the time being, Lord, till such that the process completed and the new third party comes in this side, Lord, we will be allowed to go ahead with the short-term maintenance, Lord. We are also invited, Lord.
Oh, this is only, we are only concerned with that.
Lord.
As of today, we are concerned with that.
Yes, Lord.
Your tender notice
28.
28/8.
Yes.
We are concerned with that only.
Yes, Lord. Well, I have instruction that it may take minimum of 30 days, Lord, to complete the process. So till such time, if we may be allowed to engage a third party for maintenance, Lord, I have instruction that for the stretch of 5 to
And
6
you will be
kilometers-
engaging them 9 only, or what?
No, Lord.
Huh?
No, Lord.
He is already abandoned. He is
Yes, Lord.
serving a notice. No point giving him.
With very different party, Lord. If this honorable court allows, Lord.
Don't bring another dubious party
Make sure that.
who has the credential to execute such kind of work should be brought in. He should be of A1 grade, excellent grade.
Lord.
Don't bring dubious
Lord.
person, contractor with dubious credentials who has the history of not completing a contract work.
Lord.
MS Lucino. Learned counsel. Appearing for Mr. A. Chimomi. Learned amicus curiae has submitted that due to emergent medical issue in his family, Mr. Jimomi is not in a position to attend the court today. Full stop. Para. Heard Mr. Moa Jamir, learned counsel for the NHIDCL stroke, respondent number 1, 2, and 8, semicolon. Mr. Imti Imchong, learned additional advocate general Nagaland, for the respondent number 3, 4, 5, 7, 6, 7, 11, and 12. Semicolon. Mr. Joshua Seki, learned counsel for the respondent number 9, stroke contractor, and Mr. Anybody else? Mr. Sentianger. You are for whom? Learned counsel for the respondent number 10, stroke authority engineer. You belong to which party? So you are basically an NHIDCL employee. Full stop. The subject matter of the PIL is on 4 September 2024, affidavit in opposition of 2 and 8. Page 89. Upgradation of existing road to 2- lane with paved soldier from Kohima to Mao from KM 185.540 to KM 211.709 within bracket existing KM 212.334 bracket close within bracket design length that's 26.169 comma existing length that's 26.794 km bracket close of NH dash 39 within bracket new NH dash 02 bracket close under NH within bracket O bracket close dash TSP in the state of Nagaland in EPC mode within bracket Kohima Mao Road. Right? Correct? Within bracket the project highway for short. Full stop. To execute the said contract work of project highway, comma, the respondent number 9 was selected as the contractor pursuant to a tender process as far back as in the year when 2018 post of October in October 2020 post of as per the contract agreement executed between the respondent NHIDCL and the respondent number 9 this contractor, comma, the stipulated period of completion of the contract work of project highway was 18 months. Full stop. Para. For 9 2000 In an affidavit filed on behalf of the respondent NHIDCL, respondent number 2 and 8 stroke NHIDCL on 4/9/2024 through its general manager within bracket project it was stated that despite making commitment to make the highway pothole free by 30/08/2024 by the respondent number 9 stroke contractor. Which had been causing severe traffic restrictions and safety risk. There was alleged failure on the part of the respondent number 9 stroke contractor. And as a consequence, a stretch of the highway the conditions of a stretch of a highway had deteriorated to a large extent, jeopardizing public safety and drawing criticism from the public as well as from the state government. It was highlighted that the respondent number 9 stroke contractor was regularly notified to take up the maintenance works with suitable materials and inadequate manner. But there was and it was alleged that the timelines were not adhered to and the maintenance requirements were not fulfilled by the respondent number 9 stroke contractor. Full stop. The respondent number 2 and 8 stroke NHIDCL authorities have also averred that the respondent number 9 stroke contractor was served a notice on 25/8/2024 Firstly, apprising about the failures to take corrective actions and non-maintenance of the existing road as per the contract provisions. Semicolon. And secondly, about the action proposed by the respondent NHIDCL authorities to carry out maintenance works at the risk and cost of the EPC contractor, that is the respondent number 9. As recommended by the respondent number 10, and as per the remedies available with the respondent number 2 and 8 stroke NHIDCL authorities under the contract agreement. Full stop. Para. When the matter was listed on 4/9/2024, this court passed the following order. A to A. Para. Learned counsel representing the respondent number 2 and 8 stroke NHIDCL and Mr. Jamir, learned counsel, and Mr. Seki, learned counsel representing the respondent number 9 stroke contractor, have submitted that though efforts were made to resolve the differences, no amicable settlement could be arrived at during the interregnum. Full stop. Para Mr. Seki, learned counsel for the respondent number 9, has informed that on 18/9/2024, page 33 of which affidavit? 4/9/2024.
Affidavit by the respondent number 9.
So many affidavits, it is very difficult.
Yes, my lord. Even the councils are also having problems.
4/9 or which word? 24/9.
24/9.
Maybe this is 33. The respondent number 9 stroke contractor invoking clause page 33 of affidavit of respondent number 9 dated 24/9/2024. It only note correct. Invoking clause 23.2 within bracket small Roman 1 within bracket small Roman A within bracket small Roman B Roman and within bracket small e of the contract agreement. The respondent number 9 contractor has issued a notice of termination to the respondent NHIDCL authorities conveying its decision to terminate the contract on the grounds mentioned herein. Postal. It appears that where is your contract, that clause that you have shown
Yes, my lord, this, in the affidavit filed this morning, my lord.
morning
Yes, my lord. The respondent will be-
9. Hmm? Set up.
Starting from page 22 of this morning's. affidavit.
It appears that clause 23.2 of the contract agreement provides for a cure period of 90 days or such longer period. Full stop. In any view of the matter of termination of the contract agreement is not required to be gone into at this stage. Full stop. You are also invoking termination clause, no? At present, no.
I have shown my lords, the letter dated to the 25th September 2024 by the NHIDC. In principle, they have already accepted in the letter which I have shown you.
In any view of the matter, we are not going into that.
Yes,
I have already recorded. What catches the attention of the court is that despite expiration of the contract period, comma, the physical progress of the work achieved was only 74.23%. And the financial progress achieved was 72.13%. Comma, as projected, as recorded in the order dated 4/9/2024. Full stop. Where? It has been canvassed by Mr. Jamir, Common Land Council, for the respondent number 2 and 8 stroke NHIDCL, that there is an emergency to maintain a stretch of the NH39 within bracket new NH02 measuring approximately 8.46 kilometer between KM 185.540 to KM 194.000, for which the NHID seal has already published a notice inviting tender on 28/8/2024. First off, he has submitted that after a failure of, as despite the parleys, comma, no amicable solution could be arrived at. The only option for the respondent number 4 and 8 stroke NHID seal is to proceed with the NIT. So it is submitted by him that in view of the order dated 4/9/2024, comma, the NHID seal authorities are extending the timeline for submission of the seal tenders. And presently, comma, the last date of submission of tender has been extended to, what is that? 8 is General Manager? 7/10/2024. Para. A copy of the NIT dated 28/8/2024 is found appended to the affidavit of the respondent number 2 and 8 stroke NHID seal, comma, filed on 4/9/2024. Yes, where is the completion period? Where is that? Hmm? Don't go to the contractor. It is your NIT. What is the completion time?
2 months notice.
Where is that? Indefinite.
Page number 25 of the.
No, in the tender NIT. Where is that? Don't leave any scope for manipulation by parties. Why leave you? Then contractor will come with a plea. No mention.
102 law.
Huh?
Page 102.
Let us see. 3 months.
There are two NITs. One is 2 months and the other one is 3 months.
2 stretches or what?
Yes, sir.
Okay. Then 2 stretches will be. Huh? So, hey, break it free. Otherwise, it will be difficult, no? এখন লাইন বাকিখিনি চলে যাব ইয়াৰ পৰা এই ডাঙৰ কাগজখন পাইছো 2 stretches, huh? Both dated 2 NITs, 2 notice inviting tenders, huh? Both dated 28/8/2000. correct?
Noted.
First one is at page 91.
Yes, Lord.
Second one is at,
102.
then what about this 92? 98? Another one. Hmm?
98 is pertaining to 8 kilometer land, Lordship. Page 98. It is 2 months, Lordship.
No, see 91 and 98. Looks like same, but why two you have annexed?
91 and 98 pertains to the same. contract.
Same. Why you have annexed twice?
Yes.
Huh? We get confused, right?
Yes, Lord. I'm sorry.
We have not, we are going by your submissions. We are not looking into each and every word. Two notice inviting tender, two notices inviting tender, NITs. Both dated 28/8/2024. Two stretches, page 91 or 102 আছে। একে ধৰণে কৰিব, second to ক'ব. The other one is for a stretch of 18.334 kilometer falling within KM 194.000 to KM 212.334. The relevant excerpts of the NIT, two NITs are extracted here in below 91. Or page 91, A to A, A to A. It has been submitted by the learned Mr. Jamir, learned counsel representing the respondent number 2 and 8 stroke NHIDC that what is the scope of work otherwise? Section 8. If it is maintenance work, it may be a continuous basis. Where is 2 months? Where is 2 months? Where it is mentioned, mentioned, Mr. General Manager? If it is a maintenance work, it must be on continuous basis, perhaps. Where is the 2 months? Where is the statement then 2 months?
Part of the NIT.
Where?
Page 102.
102. 102.
Yes, Lord.
Which part?
At the bottom of the table, Lordship. Time of completion at 3 months, Lordship.
Okay. For the first NIT,
Yes.
the time for completion of the short-term maintenance contract for a stretch of 8.46 kilometer is 2 months. And the time for completion for the stretch of 18.334 kilometer, for which The second NIT is floated, is 3 months.
From the date of
Full stop. The completion period is calculated from the date of execution of the date of award of the work order, stroke contract execution of the contract agreement. Full stop. An obligation is cast on the respondent NHIDCL authorities to ensure that the national highway remains safe for the public at large. Throughout the construction period of the main project highway, that is Kohima Mao Highway. As by the two NITs, tenders have been invited from eligible contractor with a view to maintaining the national highway in proper condition. We are of the considered view that the respondent NHIDCL authorities shall be permitted to go ahead with the tender process so as to complete the maintenance works in the two stretches of the national highway, as indicated in the two NITs at the earliest possible time. Full stop. In such view of the matter, we are of the considered view that the direction not to open the tenders received in response to the two NITs dated 28/8/2024, should be recalled. And accordingly, the same is recalled. Full stop. Para. Having granted the liberty to the respondent number 2 and 8 NHIDCL authorities to proceed with the tender process initiated by the two NITs, dated 28/8/2024, it is expected that the respondent number 2 and 8 NHIDCL authorities shall proceed with the tender processes in the right earnest to complete the tender process and to award the contract work to a contractor having proper credentials to execute such nature of works. Post of. Mr. Zamir, is there any possibility, Mr. General Manager, to extend the time period of submission of tender? If it is so, please tell me. 7th October is the last date of submission of tender. Okay. So I can record your
To can release a profit separate data without this enclosure. And that we have received already.
There is nothing on record. No, what have been submitted, I have been, I have not recorded anything, rescan clause. 28/8/2024 is the tender notice or not?
That is with the recent clause of the contractor law.
Huh?
That is with the recent.
No, please tell me two NITs,
Yes, boss.
both
Yes.
dated 28/8/2024. Is there any corrigendum thereafter
No.
or fresh NIT?
But they challenge this kind of. There are another courts that told in this last order that don't cooperate and don't go. So that's why we plotted a separate tender without this. Because we have to.
No, where is that?
Sir.
We have been deliberating for last half an hour or 1 hour.
I have seen their creditors are today. They have.
After end of Mahabharata, you were saying something who is him, huh? We also keeps our attention, right, on the papers. That has not been submitted by anybody.
We have done file by way of an affidavit launching, but the contractor filed an affidavit this morning. They have stated in paragraph 3 that we have also engaged, we have also proceeded by inviting.
Let us have a look also.
Paragraph-
You are not withdrawing this one,
No, Lord.
huh? And you are floating another one. Without recalling this NIT, where you have got the liberty to float another NIT? When the process has been stalled by the court, where you have got the liberty to float another NIT for the same work? Please tell me. No. Whatever is there, this project is for the same stretches of work, 2 stretches of the highway. And this court has said, don't open the tender. Risk and cost clause was never an issue before this court. It was intra-party between NHIDCL and contractor. We are not concerned with you and the contractor. Am I clear? We are concerned with the national highway only. The governments, central government, state government are obligated to the public at large. You are only the implementing agencies. What differences and disputes are existing between you, we are not with that. Now, how can you float a tender? Yes, Mr. Muazzami, please explain the situation. 4/9/2024 order is quite clear. Please try to negotiate. You could have waited for that. You could have issued a corrigendum. Yes, risk and cost clause is dropped. How can you float? You are flouting the court order.
Well, it's the instruction I have received from the engineer launching. The tender process that they have initiated this launching without the recent force of the contractor. It is funded by the authority itself, launching. And that is only for a limited stretch of road for 5 to 6.
What I have been recording for all throughout this period, what I have been recording? Keeping aside the main highway, we have been recording about the 2 stretches of the highway, right? And about the 2 NITs dated 28/8/2024. And you have said the period is extended, last date of submission. I have asked you,
Yes.
I have asked you, and he has also replied, 7th October is the last date. Then I have asked whether, because of this, maybe not so much tenders have been received. So whether there is any possibility of extension of the timeline so that I can record. Now you have come up with a plea that we have issued another tender. I was giving full attention to your submission so that I can record my order. But that was never the case. That you have floated another tender for the same stages of work. Who are you? Huh? NHIDC. That is not before which court, NIT. That NIT. Otherwise, this will be considered as a violation of the court order. You can drop the risk and cost clause from the original tender. How can you? You are not withdrawing this tender.
Yes.
Huh?
Yes.
It is on. Mr. Brother. These tender notices are all also on. The other is also on. Have you withdrawn this NITs?
No.
Then stages are same?
Same.
Then huh? Which one? Please tell me now. Again, please tell me. See, two NITs. One is for stretches of 8.46 kilometer. The other is 18.334 kilometer. Now, what about this third NIT?
First one is 16 posts, and second one of 18.87. Two units. So this, the third one is only 4.8.
No, which stretch of the? How come 16.54 crore can come down to 4 crore?
Without this cost, before that, we can go without this cost, then they get out. So that's why.
No, this is not a proper way, Mr. General Manager. You are making contempt of the court. This-
Sincere apology.
No, because
I was instructed only 17 votes.
both cannot be on. See, two tender processes, parallel tender processes is in complete violation of the court direction. How can you bypass the authority of the court? You could have come up with a plea that we like to drop the risk and cost clause and we like to issue a corrigendum to the NIT dated 28/8/2024. You cannot issue a fresh NIT. This is suggestive of contempt of court. Then tomorrow we pass an order on the third NIT. Then you will again throw another NIT. Is this the way?
This is what we have been regularly observing with NHIDC.
This is not pardonable. You come up with everything. At this stage, Mr. We'll list it tomorrow. You come up with that. We do not, otherwise we'll issue contempt. Hornbill we understand, but court is also important. You cannot violate court's order. As simple as that. Am I clear? You had number of opportunities when it was fixed earlier. What was the previous date? 25th of September. When the third NIT was floated, the other NIT? 11 September. So after 14 days, the case was listed on 25/9. You did not say anything. It was listed, no? It was listed. Deliberation was made. Some deliberation was made. We have applied our minds also. We consider all this floating of tenders and all. And Mr. Jamir has said 4/9/2024 order. Because of that, then Seki was heard. Is it not? Mr. Seki? You were heard also to some extent. Oh no, somebody was heard on your behalf. It is recorded. It is recorded. Then Mr. Jamir, you did not tell me. At this stage, Mr. Please, your name, Mr. Jamir, learned counsel for the response number 2 and 8, NHIDCL has submitted that another tender notice for the same stages of work issued on 11/9/2024. Inviting tenders after dropping the risk and cost clause incorporated in the NITs dated 28/8/2024. Full stop. Para. When the court in this PIL is seizing of the matter pertaining to the NITs, dated 28/8/2024. Issuance of fresh NIT is an act suggestive of contempt. Full stop. Para. At this stage, Mr. Jamir, the counsel for the response number 2 and 8, NHIDCL, has sought listing of the PIL tomorrow to enable the respondent NHIDCL authorities to take appropriate corrective measures. Full stop. The prayer, having regard to the prayer, we deem it fit to allow the time prayed for Mr. Jamir to list the case tomorrow. You dropped that. You are continuing to NITs. This is not permissible. Behind the back of the court. Appears to be contempt.
Hello, Chair. Hello, Chair.
Sometimes very difficult to defend this. They treated the no everything.
Where is Mr. Mohajamir? Call him. Mr. Jamir, corrective measures and to file an affidavit to that effect.
Lordship.
Have you understood what
Yes,
we have
Lordship.
indicated?
Lordship.
Though it is not our duty to indicate, but
Lordship.
still you have indicated
Lordship.
that to withdraw the third NIT and to take liberty to issue a corrigendum or
Lordship.
issue a corrigendum in the meantime.
Lordship.
And if required, we'll permit you to extend the time limit by 7 days also. There is no issue.
Lordship.
But things should be done in the proper way
Grateful.
without committing contempt of court.
Lordship. Grateful and sincere apology.
And to file an affidavit to that effect. It may be uploaded late. So you have understood?
Lordship. Yes. Obliged, Lordship.
For admission, item number 2.
Book book. Mr. Joe,
My lord,
we'd like to ask 1 or 2 questions.
yes, ma'am.
You are very much aggrieved by this provision for limited. Right?
Yes.
We'll just ask you one query. Come to say, for example, Rule 12.
Rule 12. Yes, ma'am.
Firstly, come to the schedule, or no, firstly, come to Rule 14.2.
My lord, schedule or rule 14?
No, Rule 14.
Right.
2.
That's it. Page 42. Yes, my lord, page 40.
A ZT, ZP, ET, GHT, GLT, all are graduate teacher or equivalent rank, shall be eligible for promotion as senior
Which one?
GT. Fulfill all the conditions, including completion of so and so. Now come to your schedule.
Yes, ma'am.
Seven.
7, my lord, yes.
7. And before that, come to schedule 1.
Yes, my lord, schedule 1.
Graduate teacher, above graduate teacher, senior graduate teacher,
Yes, my lord.
above senior graduate teacher, JEO.
Yes, my lord.
So it is also a double promotion for you.
No. Graduate, senior graduate, graduate.
You will become senior graduate teacher only after completion of 7 years of service.
Yes,
So it is also a jump. Basically, we understand otherwise as a normal concept that whoever below the queue,
yes, ma'am.
everybody is in the queue to upgrade himself by promotion to the next higher post. That is a normal concept. By limited departmental examination, the persons be at the last part of the queue
Yes,
are also given opportunity if they can prove themselves to be efficient and qualified by LE. Now here 14.2 says promotion and the career advancement scheme of teachers. That is one part. One part. Right. After 7 years. Next. Come to rule 12.
rule.
12. The following post shall be filled up. Have you got it?
Yes, ma'am.
By recruitment from selection from lower grades to departmental selection board on the basis of merit cum seniority.
Yes,
1. 30% of the vacant posts of postgraduate teachers occurring in a year shall be filled up through a selection process by recruitment from amongst graduate teachers and primary teachers.
having postgraduate.
Whatever. You have been bracketed there together with primary teachers. Similarly, here also
Provided they have,
same condition provided
they have postgraduate qualification.
different.
Yes,
You are not agreed by this. You are agreed by only one part. You are not agreed by the bracketing you with the primary teachers while it comes for consideration of postgraduate teacher.
my lord, there are two, sorry, fine.
But you are agreed by the limited departmental examination
Yes,
where also some rider was there provided.
yes. There's no proviso, my lord, here.
Yes. Then he must have served at least 10 years of continuous regular service.
Correct.
That is the condition.
There is,
Another condition, rider.
correct.
Here also is a rider. This goes this way, this goes that way. From primary teacher directly jumping to postgraduate teacher, junior teacher jumping to postgraduate teacher. From completely different schedule. See? Schedule 1.
Secondary and higher, no?
Uh-huh.
Which one? You check. Postgraduate. Falls under.
Where is postgraduate teacher? Higher secondaries.
My lord, one
Yes.
is secondary, elementary, and
He
one is
a
higher. secondary.
completely different schedule.
Yes, madam. Therefore, rule 14 does not come into play here because that is, it falls under higher secondary, my lord.
Whatever. You are not there. See, secondary and
We-
elementary.
Where
They were the primary teachers,
we're under secondary, elementary, my lord.
right? Where is the primary
Lordship-
teacher?
if
Where is
lordship comes
where is the
to-
primary teacher?
Yes. If lordship comes to schedule 2.
Now come to first
Se-
schedule 1.
Schedule 1 is a permanent post shown, this strength,
No. The name of the post and hierarchy pay are mentioned here.
my lord. Lordship will
Please show,
indicate.
where is the
Yes.
primary teacher?
Under schedule 1, there's no primary teacher here.
Huh?
Page 26 of the service book.
Primary teacher.
Yes,
It is there. He can jump from primary teacher to high secondary teacher. And you can also jump from graduate teacher to higher secondary teacher. permissible. Both can jump. You will jump. There are 3 stages. For example, let us examine. Primary teacher below,
Yes.
graduate teacher higher,
Correct.
postgraduate teacher also higher. They have higher rank, the higher pay. Is it not? You can, private teacher can jump from here to 2 stages, say, for example, hypothetically, directly without being graduate teacher, they can jump to postgraduate teacher. And graduate teacher can also jump to postgraduate teacher. Right? Similarly, primary teacher can jump to assistant headmaster. And graduate teacher also can jump to assistant headmaster. Analogy is same.
If it comes under Rule 14 for the in respect of postgraduate, that will be different examination, my lord.
No. Tell me,
My lord, if we go by that, then lordship may kindly come back to same paragraph, page 24, page 26.
Primary teacher.
If we go by on that analogy, my lord, page 26. Page 26, serial number 3, primary teacher, senior primary teacher, grade 2, senior primary teacher, grade 1, then area education officer, junior grade 2, senior AEO, junior grade 1. Only then they come to graduate teacher then. Then after the senior graduate, my lord. Therefore, in fact, because of all these discrepancies,
no, why then I am showing it the rule 12. Rule 12. Read it once again.
Rule 12 is for total for another different exam for postgraduate post, my lord. That does not come under Rule 15, my lord. The qualifications are different, posts also different, my lord.
Whatever.
As far as
Mr.
lordship,
Joe, whatever, if it is, if a graduate teacher desires to become postgraduate teacher, I know what is the reason behind, I am not disclosing it. I do not want to disclose why you want to become education officer. I know fully well. Question is, if a graduate teacher desires to be a postgraduate teacher, then also in the selection process, he will be at par with primary teacher. Riders are both in both entry 7B as well as Rule 12.1. Otherwise, now try to say why they cannot be bracketed. It is limited, but it is competition. Limited departmental competitive examination. Right? It is limited, but still it is a competition.
my lord, under Rule 12, it is not limited departmental examination.
No, it is selection.
It is selection. Now, and that was for particular different, totally different posts. my lord.
Okay, but
Yes.
reasoning is same.
And then in respect of Rule 15, the
You are
selection.
agreed by area education officer and selective challenge.
Yes.
Selective challenge of this nature made in this writ petition. That appears, that is to be seen with a magnifying glass. That I am conveying to you. You are not desiring to be, you are not aggrieved when you have been bracketed with the primary teacher. When it comes for selection to the postgraduate teacher, you have been bracketed.
We're not concerned about us for the time
Right.
being.
That is why
Because the examination,
I am looking at the case of the petitioners with magnifying glass. I am making it clear. Selective challenge about bracketing with primary teacher in respect of one post, but not agreed when bracketed with the primary teacher for selection of another post.
Correct.
Am I clear?
Correct, because as per the normal procedure, as per normal promotional channel, the next promotion for us in respect graduate teacher for us, assistant headmaster. But
No,
yes, my lord,
senior graduate.
that I agreed.
Senior
Graduate and senior graduate. Now, next, the right channel promotion is after the assistant headmaster. But under Rule 12, the recruitment is totally different. They have to jump to another higher secondary department. There are two separate branches, because whoever wanted to come as postgraduate, they have total different examination. So that is optional. But in our case, under Rule 15, if this Rule 15 is correct, then in that case, the primary teacher who
Mr.
are
Jimo,
2 years, who are two.
Firstly,
Yes.
one proposition. Chances of promotion in service jurisprudence, because zone of consideration have been extended. First, from one angle, zone of consideration has been extended by including primary teacher, right? In the limited departmental examination. If suppose there are 50 graduate teachers, and if there are 5 posts, suppose, just hypothetical, or 50 graduate teachers are eligible to participate in the limited departmental examination, and there are 10 vacancies, say. So chances of being successful is about what? 2%? 2% or 10%, right? 20%. Against every 5 graduate teacher, 1 will be selected. 20%. By extending the zone, adding another 50 primary teachers, 50 plus 50, it becomes 100. But vacancy is 10. Then the chance of being promoted will reduce to 10%. And in service jurisprudence, chances of promotion is not a fundamental right under Article 16. That goes. The question only remains about bracketing, because one of the factors for which it would be arguing is that my chances is reduced. That goes. Question is whether bracketing the primary teacher with some more riders and having the same qualification, whether it is a case of, because there you are competing, you are bracketed at par for the purpose of competition, but not made equal. Have you understood? We have been treated as par for the purpose of competition. Now, whether that would violate Article 14. Am I clear to
Yes.
convey my?
Yes. I got it.
It is not that primary teacher and graduate teacher are put at par. You are put at par for the purpose of participating in the competition. Whether that violates Article 14. Chances of promotion I have negated. I don't think that you have a case. But for the purpose, otherwise, open competition, everybody, doctor, engineer, MBA, veterinary doctor, simple graduate, for the IS, the most coveted service in India, everybody is equal. For the purpose of competition, otherwise they are not equal. A doctor cannot be equated with an engineer. A PhD cannot be equated with a simple graduate. But for the purpose of competition, they have been equated to get Indian Administrative Service or Indian Police Service. These are the questions which
If
are
that- My lord, if that can be understand in the way that
But-
it's open competition.
no,
But this
yes,
is in-service
yes,
competition.
Yes, in service, but still, zone is reduced, possibility is more. Possibility of being successful is more. In the open competition, you would have been competing with 10 lakh. Here it will be hardly 200 or 300. Yes, because of your entering into the service, the competition has become lesser. But I'm just putting the whatever is coming to my mind across to you. But ultimately, it is a competition. You will be jumping 2 grades. He will be jumping 4, 5 grades by the pay scale, say. Otherwise, their hierarchy is different. Graduate teacher will become senior graduate teacher. Then area education officer or assistant headmaster, right? And primary teacher will go senior primary teacher, then some other education officer headmaster. But they have been permitted to jump from here to here. And you are also permitted to jump 2 grades higher. And ultimately below it, for the purpose of competition, you have been made equal.
I have understood. Lordship, then competitions has to be among the equals. One,
So
that
we-
is my expect.
Argument, but
Number-
show me some
number-
with authority.
Number two, if we read together Rule 12 and 15, in Rule 12, specific qualification has been prescribed that one should be postgraduate to come to higher secondary. Now under Rule 15, no qualification is prescribed.
No, but
So
other
this is the
conditions
difference
are
I'm
there.
saying.
Other conditions are there, Mr.
So
Joe.
in Rule 15 is totally different because this is
Let us see.
Rule 12 does not talk about limited department examination. This is open and this is
See.
totally different channel of promotion, my lord. As I have repeatedly
If you,
said,
if
my
you,
lord.
no, if you can prove whether see 7A,
My lord,
7A and 7B, there are 2 in the
rule,
schedule.
lordship schedule 1 or 2, my lord.
2.
7A.
80% by promotion, 20% by departmental examination.
Yes, my lord.
Now A,
Yes.
promotion.
Yeah.
The post of assistant headmaster, JEO, shall be filled up by promotion on recommendation of the committee. Selection shall be made from among the confirmed senior graduate teacher and senior legal assistant, provided he has completed at least 7 years as senior graduate teacher and senior legal assistant. And to become senior graduate teacher, you need how much years of experience?
7 years, my lord.
7. 7 plus 7, 14. 14 years of experience. Now come to B. 20% of all the vacant posts of junior education officers assistant headmasters in a calendar year shall be reserved for recruitment through limited departmental examination from. So here it is not open for senior graduate teacher.
My lord, nothing. That's what we're saying.
Graduate teachers
Yes,
and primary teachers.
yes.
And those holding equivalent posts with 50% marks where 50% marks where?
But
Ms. Supri can explain us. Have a
Lordship,
copy.
Lordship, I have. Lordship,
Have you understood?
Lordship,
See,
Mm.
once again we'll read
Mm.
7B, or we can read 15.1 also. No issue.
20% of all the vacant posts of junior education officer, assistant headmaster in a calendar year shall be reserved for recruitment through limited departmental examination from amongst the graduate teachers, primary teacher, and those holding equivalent posts with 50%
yeah.
marks. Yes, yes.
With 50% marks.
Yes, yes,
And read slowly the later part.
Yes.
Relaxable by 5%. Okay.
yes.
To that extent, yes.
Mm,
For scheduled tribe,
mm,
scheduled caste,
mm.
differently able
Candidates,
candidates,
Degree, postgraduate level. So
This
your
is,
lordship,
no, this is differently able candidates, degree or postgraduate level.
yes. Post-
Where?
Degree postgraduate level with BA, PSTE, DLED, and who have served at least 10 years of continuous regular service as graduate teacher, primary teacher, equivalent post. So your lordship, 50% marked, relaxable by 5% for ST, AC, and differently able in the degree as well as the postgraduate, the aggregate mark, lordship, the percentage.
Some order appears to be missing.
No, but lordship, if they score below 45%, then they are not
Is
eligible.
it properly constructed sentence? Tell me from the, as an officer of the court,
Yes, lordship.
don't
And those
for
holding
the sake of
equivalent-
opposing it.
Lordship. And those holding equivalent posts with 15% marks, relaxable by 5% for scheduled tribe, scheduled trust, differently able candidates, degree postgraduate level, with a lordship of, yes, a little bit twisting is there, but still then your
Appears to
lordship.
be not properly constructed sentence. Meaning may be there.
Mm,
See, if you defend
No,
about
no,
the construction of the sentence, then then we'll interpret it differently. Yes, it may not be properly constructed, but is it your submission that with 50% marks at degree or postgraduate level?
Yes, yes, relaxable by 5%, so it will be
If
45.
relaxable, you
Yes.
remove the relaxable part.
Oh.
Otherwise, with 50% marks
Yes,
at degree or postgraduate level,
yes.
is it the proper construction? It should be the proper construction.
Lordship, interpretation could be, depends on person to
But
person.
that I don't know,
so
it is you,
As per my understanding,
50%,
yes.
no, as per, there should be consensus about it.
So 50% means
Marks
the
At the
mark,
graduate or postgraduate level.
It-
Relaxable is different. thing.
yes, yes. So-
Please, just try to understand.
So Lordship, what I'm saying is that in the degree, in the,
That is what I am
that
saying.
could be 50% of the total marks.
That is
or-
what I am trying to convey.
Okay,
That
Lordship.
at is missing perhaps, the at word is missing.
Mm,
50% marks. Right,
yes,
there should be some comma after 50% marks,
mm,
relaxable or within bracket. Relaxable by 50% for scheduled tribe, scheduled caste, differently able candidates,
Mm.
there should be bracket.
Mm. True.
At degree.
yes,
Or
Lordship, yes,
That
yes.
should be, that is
Yes,
what I am
yes.
trying to. Otherwise, it is
Mm.
not a properly constructed sentence.
Mm.
It appears the meaning is that
Mm,
graduate in primary teachers and those holding equivalent post with 50% marks at degree or postgraduate level
mm,
with so and so degree and who have served at least 10 years of continuous regular services, graduate teacher or primary teacher will be eligible to participate.
That should be an interpretation, but it's not there.
We have to also understood now. We have to
Because-
understand.
In fact, because of all these discrepancies, they have set up a committee to review the entire service rules. I have annexed the judge order, my lord. Yes, I have annexed. They have, after coming to know that these rules is first, these rules not applicable, so they have constituted a committee. Nature. Please, without possible final order.
Yes.
After considering all these, government has come to a conclusion, government, not department, government come that this suit has to be reviewed. Committee is constituted now. I have annexed the order now.
You have annexed. You
Yes.
have annexed.
Yes, I have annexed.
I have seen.
So therefore
But
now
that was far back.
they themselves admitted that this rule is not applicable, my lord.
No, no.
If lordship comes
They
to,
have set up a committee for review. We don't know this for review of this particular provision or not. And
And-
when
the,
something comes before the court. We have to decide.
yes, ma'am.
That question, that competition element is to be there in the LDC also.
I agree.
And
If-
primary teachers, though in a different grade, they have been asked to hold either graduate or postgraduate degree.
Degree.
They have been asked to hold.
And that has not been specified under Rule 15. That primary teacher has to have postgraduate, or that is not prescribed. That is my contention. Under Rule 12 prescribed, postgraduate.
Otherwise,
Under Rule 15, qualification is not prescribed. That is the whole problem. Man. The difference between 12 and 15.
50.
Now,
That's right.
lordship will see,
what means?
just,
That appears to be not true. Mr. Joe.
my lord,
One is for graduate teacher, graduation is the minimum qualification. Understand? But for primary teacher,
There is no qualification prescribed.
then you continue.
My lord, in my humble submission, under Rule 15, Lordship, I'll just read out for the benefit of Lordship, my lord, for community Lordship. 20% of all the vacant posts of junior education officers / assistant headmasters in a calendar year shall be reserved for recruitment through limited departmental examination from among the graduate teachers / primary teachers and those holding equivalent posts, with 50% marks relaxable by 5% for scheduled tribe / scheduled caste, different able person, degree, post, graduate level, with so and so, and who has served at least 10 years of continuous service, regular service as a graduate teacher, primary teacher equivalent. No educational qualification prescribed. This is the difference, my lord.
What is
Now-
good?
Now coming back to,
I'm failing to understand. That is what,
Yes.
but you interrupted me in between.
I'm sorry.
When I started only a few words.
Fine.
For primary teacher and equivalent rank, I have said that minimum qualification is senior secondary.
my lord,
And for graduate teacher,
graduate,
graduate.
degree.
And the highest qualification may be PhD, double PhD, triple PhD. That is not the requirement.
Preferable, my preference. My.
That is one thing.
That minimum.
Minimum, I am saying. Here, for the primary teacher
Yes.
to participate in the
Limited.
examination,
Yes.
he has to have at least graduation.
Very.
That
That's
is what
that's what I'm
qualification is prescribed.
Yes. Prescribing those qualifications
For graduate teacher, it is implied. They have already.
implied.
But to put at par, the authority, rule-making authority has said, Look, Mr. Primary Teacher, you should have graduation. Then only you can participate in the limited examination. That is what first they have put. Now let us see educational qualification for graduate teacher. All to be appointed, all must have TET. So you remove TET. All to be appointed as a graduate teacher, one should have TET, that teacher qualification. And for primary also it is there.
Yes.
Now for graduate teacher, what is the qualification?
Or-
7B Roman 2 small b. You must have B.Ed.
Lordship rule
7
qualification is prescribed under Rule 6, my lord.
7B.
Rule 6, page 6, my lord. Rule 6, page 6, my lord. Sub-rule 8. And sub-rule 9 is primary, my lord.
Huh?
Yes. Page 6, sub-rule 8 is the qualification for graduate. Sub-rule 9 is the qualification for primary teacher, my lord.
Where are you reading?
Page 6, my lord. Page 6.
This.
Yes, my lord. Page 6. Sub-rule 8. Rule 6, sub-rule 8, my lord.
Page 6, sub-rule 6.
Yes, my lord. Same with Rule 7 also, lordship, correct.
Two.
Yeah.
Come to
Same.
7B.
My lord.
7 is qualification for direct recruitment.
Yes.
A is A's.
Yes.
B is education qualification.
Yes.
First Roman 1 is PG, postgraduate teacher. Roman 2 is required educational qualification for direct recruitment to the post of graduate teacher
Correct.
in various subjects shall be as follows.
Yes.
A is graduation with 50%.
Yes.
There in the impugn provision, primary teacher have been made to have 50% and graduation. Next, B, Bachelor of Education. B.Ed. Right?
Yes,
Now come to below Roman 3.
yes, primary teacher.
Teacher eligibility test, that is common for both. Now, Roman 3, required education qualification for recruitment to the post of primary teacher. A, senior secondary, stroke graduate with at least 50% mark. Now, this senior secondary pass has been excluded from the LDC.
That has not been specified, my lord, whether
Specified.
it excluded or not.
Specified, not specified mean out. Kicked out. As simple. Only graduate with at least 50% marks have been made eligible. Next. Going. We're trying to understand.
Yes, ma'am.
Next is PST or DL Ed or B.Ed. So all these have been made eligible. B.Ed, PST, DL, ED to take part in the LDC. And next condition is 10 years of continuous regular service as graduate teacher or primary teacher. So what? Both of you should have 10 years. Now, question is that for the purpose of participation, they were made at par if they have this qualification. So whether for the purpose of participation they are made par, whether Article 14 is said to be violated.
Yeah.
How? I have given an example of large examination, and this is I have given an example of EPSC examination where a doctor, veterinary doctor from Harvard, MIT, simple graduate, simple past graduate without honors, everybody is treated equal to take part in the competition.
In case of open market,
Open. Here it is, sphere is limited.
limited.
Chances are more
Within service, my lord.
in service. How it is violent. Otherwise, since after independence, EPC examination is there already. Nobody has challenged it.
To understand our case better, my lord, if we lordship knows very well
Writing.
about
Will you writing after we'll resume that debate?
Yeah.
Put one day, first one there. Put one day, three. Go to the.
As per this schedule, there are two kinds of promotion. One is normal promotion. The other is accelerated promotion by limited departmental examinations. For normal promotion, you are not eligible. You are not senior graduate teachers.
I have been told whether all of them are regular or senior graduates.
Your pleading is graduate teachers.
My lord.
Like them.
I understand. Normal promotion.
Normal promotion, you are not eligible. By the LDC, like the primary teacher, you are also given the opportunity of accelerated promotion to jump to grade higher. Right. On that basis, you are on equal footing. Both were given. Only thing is that your pay scale is higher or grade is higher. Their grade is slightly lower. Qualification wise, they are also equal.
No,
No, please.
they are not equal.
Experience 10 years in the service. Plus graduation 50%. B.Ed degree, TET. Only thing is that you extended the service as a graduate teacher and they extended the service as a primary teacher. Right. But both are ineligible and on deck for normal promotion.
No.
The question of locus also comes in. When you are not eligible for a particular thing by normal promotion, how can they eat into your quota of promotion? Otherwise, you are not eligible by normal promotion. You will be complete. The query of the court is that you are otherwise not eligible to be promoted by normal promotion
Going by normal promotion.
to the post of
Assistant headmaster.
assistant headmaster. For you also, it will be accelerated promotion, 2 grades higher. Otherwise, by normal promotion, you have to become senior graduate teacher. Then, thereafter, assistant headmaster or education officer.
Yes.
If we go strictly by the schedule, because you have challenged the schedule,
Correct.
a part of the schedule,
Correct.
but we have to read the thing in totality. That is the question one has that arises in our mind. One of the question. How to deal with this? Eligibility of the petitioners itself come under a cloud.
In fact, the senior graduate teachers should have been before this court.
My lord. My lord.
Correct.
In fact, the senior graduate teachers should have filed this petition.
Lordship will see if Lord, now, yes, my junior remind me, if Lordship see our representation, this is for the entire graduate, senior graduate teachers.
No,
Lordship may
you-
comes with page annexure,
But we have to go by your pleading.
annexure. This is part of our pleading, my lord.
Who has participated in this repetition? No senior graduate teacher is before this court.
Paragraph.
Tell me from the repetition, is it the average? At least out of 50, anybody is senior graduate teacher? Challenging a virus is not an easy issue.
I don't
think
whether they are all graduate.
you could go by your averments.
I'm not sure.
Paragraph 3.
Yes.
First line.
Yes, I have seen my. Pongchilo, sorry, Pongchilo, where is your petition number? Pongchilo, petition number.
And every equivalent grade for that matter. Every equivalent grade for that matter, like say, graduate teacher Hindi. They have a grade senior graduate teacher Hindi.
Number.
Language. Language teacher, senior language teacher. Then C schedule Hindi, graduate teacher Hindi, senior graduate teacher Hindi.
Yes.
Then language, language teacher, senior language teacher. So normal promotion route is for the senior graduate teacher, senior language teacher, senior graduate teacher Hindi, for all those, the normal promotion. It is also a promotion for you by 2 grades. For them, maybe by pay scale, maybe more. But you are also given the opportunity to participate in the competition by way of sheer merit, only merit. The criteria is for you also merit. Now, otherwise you are not eligible to be promoted to the post of junior officer or assistant headmaster by normal promotion. This is the difficulty arises. If out of 50, any one is senior graduate teacher, yes, at least the challenge will remain for him.
My lord, I have got information now, particularly petition number 2. He is already assistant headmaster and most of them are senior graduate teachers. So that in that case, I may be able to ascertain because I'm certain that petition number 2 is already assistant headmaster. So now I have to-
Then the angle will be different.
Now, therefore, the proportion.
They will eat into your quota. But for them, otherwise this pleading is very difficult for us to solve. We cannot go by
Correct.
the verbal statement.
That's what. So, especially petition number 2, I got into information now. He is already inspector or the assistant headmaster for more than 2, 4, 5 years. Now, so I have to, in that case, yes, lordship is right.
For him,
Who are
There is nothing to challenge. For him, there is nothing to challenge. For petition number 2.
Nothing to challenge.
Because his seniority will always be maintained.
Yes. That's right. So now therefore.
He has to be deleted.
Correct. Therefore, the remaining, in that case, I may be allowed to
If
ascertain.
any of the others,
Ha.
senior graduate teacher,
Correct.
they might maintain the challenge in a better way. But simply by becoming graduate teacher, it is an academic exercise, might be. Because your chances of promotion, their chances of promotion, normal promotion, you are not affected. You are not affected by the normal because you are not eligible.
If we were graduate.
A graduate. Going by the environments, I am saying. If something comes out, then you have to
Correct.
submit your pleadings to that effect.
Then in that case,
Because
may
we
be-
have been scratching our head to find out.
I-
Yes, MS Sukri, whether that your
yes,
one-page document is substantiated
yes.
by something more.
Yes, I've got it. Lordship,
Anything of any authority,
yes.
broad-based.
Lordship, though it is from the High Court of Delhi as well as the High Court of Rajasthan, though it does not have a binding effect on this court, yet it has a persuasive value. So I can place on that record. But your Lordship has clearly pointed out, now came to the that, see, this petitioner and the primary teacher who has the graduate degree, who has served for 10 years, they are in the same class. It is only who are outside the class can challenge the bias of the rules, but not the petitioners, your Lordship, because they are equal. Regarding this, Lordship, that, the other day, your Lordship,
With the graduate teacher pleading, Lokas will be in doubt.
if,
Subject to your information,
yeah, I agree.
some of them have become.
Now we come
senior
from
graduate
the,
teacher.
some are senior, some are headmaster. So we have to clarify
There has
that.
to be helpful for you to maintain the challenge.
Yes.
And there has to be some more pleadings to that effect on record. Merely by the statement, we cannot.
I got.
Lordship, the limited departmental examination is open to many other grades and not only to the lower feeder posts. This is held in 2016 SEC online Rajasthan, your Lordship, at para 11. Para 11, your Lordship, 1, 2, 3. From the third line, your Lordship, as per the provisions. Has your Lordship got it? As per the provision. As per the provision of the Department of Post, Inspector of Post Recruitment Rules 2001, for short the rules, the posts of Inspector of Post are required to be filled in the ratio of 33.34% by direct recruitment through Staff Selection Commission and 66.66% by way of promotion through limited departmental competitive examination. It is true that the Inspector of Post by way of promotion is not recruited from a single lower cadre grade scale of the postal assistant only, but from among various cadres grade scale like stenographers, LDCE, staff of Director of Postal Account also. But then on their account, the channel of promotion provided may be by way of limited departmental competitive examination shall not cease to be a channel of promotion provided to the employees holding the post specified. In other words, merely because the post of Inspector of Post by promotion is filled in by way of limited departmental competitive examination from amongst the employees holding the post specified, their promotion to the post cannot be treated as direct entry. So, Lordship, here also, even in other states also, for the LDE, they have other lower grades. Not only the feeder posts are eligible, Lordship.
They have found in
Mm.
also. Constable, sub-inspector of police,
Mm,
they are made eligible for the purpose of LDC.
Yes,
Now,
Lordship.
question is,
Mm,
the constitutional validity
Yes.
is not challenged.
Yes.
So if the constitutional validity is not
Okay,
challenged,
Lordship,
that is what the
okay,
question.
then Lordship, I may be allowed to.
Here the constitutional
yes,
validity
yes.
is challenged.
So, Lordship, even the constitutional validity regarding with that
Yes.
unequals are treated equally in the next Lordship, SCC 1976 SCC Online Delhi, Your
Hmm.
Lordship, yes,
Yes.
at para 2,
Para
at
two.
para 2, Lordship. Are the regulation ultra virus?
Hmm.
The rules are themselves made by the Department of Personnel and Administrative Reforms under the proviso to Article 309 of the Constitution. The same department is authorized to make the regulations under Clause 2 of Paragraph 2 of the 4th Schedule. The first regulations made in 1964 enable the stenographers to compete along with the assistants at the limited departmental competitive examination. The question whether assistants alone should be allowed to compete or whether stenographers also should be allowed to compete at the said examination is entirely administrative. There is no law involved in it. It would require strong evidence in the language of the rules to show that the government department which framed the rules, which also framed the regulations and which acted upon the same by allowing the stenographers to compete at the said examination from 1964 to 1969 did not know its own mind as reflected in the language of the rule. Such strong evidence is not forthcoming from any provisions of the rules. Then Lordship para
6.
6, Lordship.
Six.
Yes, para
5
6,
reasons, at least one is convincing.
Lordship.
Last one, finally.
Yes.
Other things are not convincing
Mm.
because here they enjoy same pay scale.
Mm.
All these things are there.
Yes.
Only finally,
Yes.
it is only a person who passes the limited departmental competitive examination who is
Who is
allowed to
allowed to
become a
become-
section officer. This
Yes.
is a common test for both the assistant and the stenographer.
Yes.
After passing this test,
Yes.
they stand on a footing
Footing
of
of
equality.
equality, Lordship.
Any difference in their qualification and experience prior to the passing of the test then becomes immaterial.
Yes.
Article 14 and 16 are not therefore violent.
Yes,
This is
Lordship.
only one.
Yes.
Otherwise, other factors are
Mm.
equal.
Then,
This thing.
Lordship, regarding on the principle of the equality, Your Lordship, I have
Okay. Anything?
2014 8
But question is, there has to be some additional pleadings.
No, Lordship, even if they, otherwise your Lordship have extensively heard the matter, Lordship. So,
On the basis of these pleadings, we can decide.
yes, Lordship. 2014 8
But question is, yes, Mr. Joe, what is your submission at this stage? Shall we close? Then we can close.
Lordship,
On the basis of available materials.
sorry, according to the information, some of them are senior graduate teachers, so which I have not ascertained properly. And especially petition to is no more senior graduate even. That is one. Other ways for the better understanding of this case, I thought I'll just read out few paragraphs from the
Not
petition
question.
plus.
First question.
Yes.
Shall we add a matter on the basis of available materials on record plus the respective submissions of the council?
No. That, my lord, in that case, I may be given short time so that correct facts will be placed before the
Then
court. After that, we'll go on.
Lordship,
At the time of drafting. Let me see now. Need to realize. When did it? Yes.
It will be only rolling over. But we were at different places during October. November first week and second week.
No problem.
We will be in principal seat, both of us. You can argue through BC, but we will be together.
But Your Lordship,
Okay.
if that is the case, Your Lordship, my prayer is that the interim order should be vacated. Because Your Lordship, it has been, interim order has been passed and the department has been facing difficulty, Your Lordship.
Without filing any vacation petition since 2022. Wait for 2 more weeks.
Just to ascertain whether they're really senior.
Any interrogatory application for vacation of the interim order, you were quite happy with that.
If none of them are senior, then yeah, Lordship is right. I agree.
Because if ultimately it turns out that none of these petitioners are senior graduate teacher.
At a
it will
time of,
fall. You file what within, I'll fix a time limit
no problem.
for submission of your additional pleading.
No problem.
So that it is available
Yes.
in the record, it is also available to the learned additional advocate general. And if she is so advised, she can file a reply, counter. She can verify whether
Very
you are
much.
really
Really senior or not, right?
senior or not. And
Rick-
for, and unnecessary petitioner should be deleted. If petition number 2 is already
Assistant
assistant,
headmaster,
then he has no right to challenge.
no more. Going by these pleadings.
We'll say that you file your additional pleading by 18th of October.
I'll be doing some for 1 week, for one criminal case evidence. So if also can permit me, since matter will be decided in November, if I'm allowed to file before 23 of October.
23.
Yes, I can do that.
MS Sukri. Thereafter, any addition from your side to ascertain how much time will be required?
Record will speak, my lord,
Yes,
about
the
that.
report
Record will
will
speak.
speaks only, yes.
Because we have to annex the order only.
Heard. Mr. Ajo, granted counsel for the petition. And Ms. Vishupri, granted additional advocate general Nagaland for the state respondents. During the course of his submission, Mr. Ajo, granted counsel for the petitioner has submitted that a necessity has arisen to ascertain the fact as to whether any of the petitioners are
Graduate senior.
is a senior graduate teacher or of equivalent or senior graduate teacher or graduate teacher. Or is holding a post, holding an equivalent post. So he has submitted that ascertainment of such fact is required to maintain the challenge to the virus of the impugned provisions of the Nagaland School Education Service Rules 2017. He has sought for 2 weeks time. I'll fix it 23 to file additional pleadings along with supporting documents on the issue. Full stop. Having regard to the nature of challenge made in this petition, the prayer made by Mr. Joe Granite Council for the petitioners is allowed. Any additional pleadings by the petitioner is to be submitted on or before 23rd October 2024. First stop. By serving a copy to the Learned Additional Advocate General, Nagaland. First stop. If any reply is to be filed by the state respondents, then the same shall be filed within a period of 1 week thereafter. Yes. Second of business. Release the case on 8 November. Both will be there.
Lordship.
Timing will be decided
No problem.
either at 10:30 or 2 o'clock,
No problem, no problem.
subject to the volume of business there.
Majum. Majum.
For orders, item number 4 and 5.
Yes,
Members of Lordships, this present application has been filed for praying for a direction that I may be allowed to amend the main criminal petition, that is Red Petition Criminal 12 of 2024, which is pending disposal, Lordship. Here, Lordship,
yes, any objection? Objection.
Lordship.
Heard Mr. Supon Gutiwaling,
Lordship.
Learned Counsel for the petitioner. MS Mr. Oh, applicant.
Lordship.
The state petitioner. Mr. Thiba Hong. Oh, sorry, B. Ju. Learned. Government advocate. Learned public prosecutor. For the opposite party, number 1, 2, and 3. Opposite party, that's respond number 1, 2, and 3, and Mr. Anguli.
That Anguli, madam.
Jad Anguli. Learned
number 4.
Central Government Council. For the opposite party, that's respond number 4. Full stop.
My lord, I have filed my affidavit of opposition.
Now, do you have any objection to the interlocutory?
No, my lord.
The applicant, as the writ petitioner, has preferred the accompanying writ petition, WPC criminal number 12/2024 to challenge legality and validity of a detention order dated 13/5/2024 and a confirmation order dated 22/05/2024 passed under the Which act?
Lordship, subsection 3 of section 3 of the National
Of
Security
the
Act.
National Security Act 1980. The instant interlocutory application has been filed by the applicant to the petitioner. Seeking amendments in the accompanying writ petition. Seeking certain amendments in the accompanying writ petition. Full stop. It has been averred that during the pendency of the accompanying writ petition, the Chief Secretary to the Government of Nagaland by an order of confirmation dated 9/8/2024 has confirmed the preventive detention of the petitioner's husband by extending his detention for another 3 months. Full stop. Such development has necessitated the petitioner to file the instant interlocutory application seeking amendment in the accompanying writ petition with the incorporation of a new paragraph as paragraph number 5A to the following effect. It bolded us. It has been averred that in view of the necessity to challenge an order of confirmation, dated 9/8/2024, it is also required to seek an amendment in the prayer portion of the accompanying writ petition with the addition of the following paragraph. The paragraph as well as notification. Before the words Mr. Walling, learned counsel for the petitioner, has submitted that since the order of confirmation dated 9/8/2024 has been passed during the pendency of the writ petition, the petitioner be granted the leave to amend the accompanying writ petition in the aforementioned manner. And by incorporation of the aforementioned paragraph and the prayer, the nature and character of the accompanying writ petition is not going to be changed. Mr. Jivomi, learned public prosecutor, appearing for the state respondents, appearing for the opposite party, number 1, 2, and 3, and Mr. Annually, learned Central Government Council, appearing for the opposite party, number, yes, responded to have submitted that they have not received any instruction to oppose the prayer made on behalf of the petition. They have submitted that petitioner shall file an amended writ petition at the earliest so as to, which would enable them to respond to the amendments affected in the accompanying writ petition, in the amended writ petition. Having regard to the nature of amendments sought in this interlocutory application and having and considering the fact that by the said amendments, the nature and character of the writ petition is not going to be changed to the prejudice of the opposite parties, the instant interlocutory application is allowed. Full stop. The applicant writ petitioner shall file an amended writ petition
1 week, Lordship.
We'll be having vacation, so tell me a date. Yes. On or before
17, Lordship.
7/10/2024. Post of,
Right.
in the writ petition. In view of the order passed today in the connected interlocutory application, I so and so, list the writ petition on 21. Oh, it will be division.
Yes,
bench.
Lord.
23/10.
2030, Lordship.
23/10. Right?
Obliged, Lordship.
Okay.
For hearing item number 6.
It please your lordships. My lord, on the last occasion, though we have filed an affidavit showing that the private respondent, the respondent number 1, has refused to appear in the case, my lords were concerned about the appointment order.
Refuse to trustee.
He refused to contest in the case, my lord, which we have already filed by way of affidavit.
Anyway, I where in IA?
No, my lord, we filed the affidavit on 18/6/2024. Dusty service, first registered,
Mr. Seki
My lord.
is in connection with IA seeking condonation of delay.
your lordship,
That time appeal was not born.
my lord.
After condonation of delay, appeal was born, but I have seen that no notice has been issued to the respondent number 1,
My lord,
though it is admitted.
your lordship, it was by the order of the Zolmo court that we were allowed to issue dusty service,
In the IA, Mr.
my lord.
He-
Your lordship,
It was in connection with condonation of delay.
my lord,
At that point of time,
my lord,
it was not sure whether the period of delay is going to be condoned. Right?
my lord,
That if the-
your lordship, your
and
lordship.
that respondent number 1 can have the liberty, okay, I will not contest IA.
Your
It might
lordship,
be dismissed, it might be dismissed, the appeal will be dismissed.
my lord, your
But
lordship.
here, if your appeal is allowed, his appointment is going to be,
My lord, then while agreeing to your lordship, if my lord may kindly grant this, we may be allowed to give a substitute notice by way of newspaper publication because we gave him the petition, but he has refused.
no, will allow you to permit the serve the notice through the office of your head of the office.
Head of the office,
Sir,
Yes.
My lord.
Shivahom will
your lordship,
do that needful.
my lord, your lordship.
That will be more appropriate. I am saving you cost.
Yes, your lordship.
My lord, after, may I
You
please
have
lordship?
submitted an affidavit.
Yes, yes, my lord. I furnished the appointment order of the private
Yes.
respondent.
Now you served a notice through this director of animal husbandry and veterinary services, Nagaland. At the office of, he is appointed where?
Sungro, VHC, the Veterinary Health Center, Sungro,
And which district?
under
Woka,
Chief Veterinary Officer Woka.
Chief veterinary, through chief veterinary officer.
Okay.
It is admitted, but notice was not issued.
My lord.
Notice is not issued. We have to issue notice. Third, Mr. Joshua Segi, Learned Counsel for the Writ Appellant, and Mr. E. Thiba from Learned State Counsel for the respondent number 2 to 5. Full stop. In this writ appeal, the writ appellant has challenged a judgment and order dated. Order dated.
Your Lordship,
2023.
24/3/2023.
Passed in a writ petition, WBC number 115/2019,
My
and
lord.
an order dated
Yes, your Lordship. 28/8/2023.
passed in a review petition
Number
number
2,
2/2023.
Lordship.
Full stop. The writ appellant is aggrieved. Is also aggrieved by the subsequent appointment made in favor of the respondent number 1.
My lord.
Who was the writ petitioner
Yes, my lord.
in WBC number so yes. Full stop. It is noticed that the writ appeal has already been admitted for hearing on 14/8/2000, has already been admitted on 14/8/2024. Full stop.
My lord.
It is also noticed that the notice has not yet been issued to the respondent number 1. That's writ petitioner, whose appointment is likely to be affected in the event the writ petition is allowed. Full stop. It is full stop. From the affidavit filed by the state respondent number 2, 3, 4, and 5 in deference to the order dated 11/9/2024 and 26/9/2024, it is noticed that the respondent number 1 has been appointed as a medicine carrier in the veterinary health center. Veterinary or what?
Yes, your lordship.
Veterinary health center,
Yes, your lordship.
Sungro, under the office of the chief veterinary officer, Ukha,
My lord.
Yes.
Your lordship.
by an order of appointment dated 18/8/2023. Full stop. Let notice be issued to the respondent number 1, that's writ petitioner. Full stop. The notice is made returnable in 4 weeks. Full stop. The writ appellant shall take steps for service of notice upon the respondent of number 1 writ petitioner by registered post with AD within 2 working days from today. Full stop. In addition, the writ appellant shall serve a notice, serve a copy of the notice to Mr. Thiba from the State Council, who in turn shall take necessary steps for service of notice upon the respondent number 1 that's writ petitioner to the chief veterinary officer, Ukha.
My lord.
And
Sungro Woka.
Huh?
Chief Veterinary Officer Sungro
No,
Woka.
that will be Walker.
that is Sungro, but
Yes.
chief veterinary officer
Will
Ukha.
be at
Yes.
Walker. Yes.
And thereafter place a acknowledgement received before the court
My lord.
regarding service of such notice on or before the return.
My lord. Bless you, Lord.
Much obliged.
This is the case of the province.
Lorships.
Password. Very like ACS like. Mula put it looking in there. Send me there.
Very sir.
Yes. Tomorrow. Yeah. I hear what? A donation. I am for donation of. Yes. When was it was posted?
One, five. The bonding out.
May it please my lord. Lordship, I beg to mention, writ petition. Lordship, to be listed tomorrow because of subsequent development, Lordship.
But
Ju-
motion,
No, Lordship, it's pending. To be listed tomorrow, Lordship.
for what? Orders?
For orders, Lordship. Lordship, I also have filed IA, two IAs that is till now number has not been given. Lordship, the petitioners the two petitioners were before this honorable court, they challenged the appointment of assistant professor through backdoor. However, in the meantime, NPSC advertised assistant professor post, and now two of them, they have been selected for appointment as assistant professor. Now they want to, the department is summon them to delay their name in the writ petition by today, but it may come up tomorrow, Lordship, for deletion of their names only, Lordship. To be listed tomorrow, Lordship. Obliged, Lordship.
Lordship, if your lordship is pleased, I would like to move an unlisted review petition tomorrow.
Okay.
Obliged.
Lordship, may I be permitted to move on fresh matter tomorrow?
Writ
Says-
petition.
Yes, writ petition. Deeply obliged.
The- court must-
May it please my lord. I'm Lordship, I have a similar player. I may be permitted to move an unlisted item tomorrow, criminal revision petition. I'm obliged.
Lordship, I beg to mention item 32, Your Lordship. Learned counsel for the petitioners in this post, Your Lordship, may kindly grant 3 weeks' time, Your Lordship, for hearing.
Bank counsel appearing for Mr. Who is the petitioner? Who is in this post?
Anungla Longkumer.
Appearing for Miss Anungla Healthcare. Learned counsel for the petition submitted that Miss Anungla is in this post and has thus sought for adjournment for 2 weeks. Please, the prayer is allowed. In view of the ground cited for adjournment, the prayer is allowed. Leave the case after 2 weeks.
Oblige, Your Lordship.
Mr. Lordship, I'd like to mention item number 25.
25.
Yes. This matter be listed after the Puja vacation.
On the prayer of Mr. Yungarvati Lanit's Central Government Council for the respondents, the matter stands adjourned for 2 weeks. MS or comma with consent from MS
Rikonokiso.
Learned Council for the petition. This is the case after 2 weeks.
Lordship, I beg to mention for item number 16, 17, and 18. Lordship, kindly list the matter after the puja break, Lordship.
On the prayer of MS so-and-so Learned Council for the petition, and this is the case after 3 weeks.
Yes, Lordship.
Most of the cases.
Must oblige.
Mr. Kivamo. Understanding
I'm for the state, yes.
for the state council, and state council for the response, is present.
Much obliged.
Much obliged.
May I please, Your Lordship, I beg to mention item number 19, Lordship. Lordship, it is the prayer of, the joint prayer of the councils, the parties, to fix the matter on
CD room
18,
sound.
Lordship.
Learned Council for the petitioner and MS Lucino.
Yes, my lord.
Learned Council for the private response.
Respond number 1, my lord.
Response number 1. Have made a prayer, joint prayer to release the case after.
To list the matter on 18 November, Lordship.
18 November, is it the day is sacrosanct or what?
Lordship, there are
This is the
councils
case
from out of station
Huh?
involved in this.
on 18/11/2024.
Lordship, I have similar prayer for item number 20, Lordship. Let it come up after 3 weeks, Lordship.
Okay, on the prayer of Mr. C.D. Rumsang, Learned Counsel for the petition, which is made with the consent of the Learned Counsel for the respondents, release the case after
3 weeks.
3 weeks.
Much obliged.
Please, Your Lordship. Lordship, if I may be allowed to make a mention, Lordship, I have filed an IA today, my lord. And if I can be allowed to.
For what?
Lordship, this is for deletion of his name from the petition, Lordship. Here, the petitioner is going for further medical treatment, Lordship. So he wants to withdraw his name from the petition, and the writ petition is fixed for 14th of October. That is right after the puja. So if he may be allowed to delete his name from the petition before that, my lord. So if oblige, my lord. Oblige.
Please, Lordship.
Yes.
Lordship, I beg to mention item number 11, Lordship. Item 11, Lordship. Yeah, I'm for respondent number 1 to 7, Lordship.
Okay.
Lordship, we are yet to file affidavit, Lordship. If
Mr. D.G. Mumi, Learned State Council has submitted that the necessary instructions to file a counter affidavit are not yet received and have thus paid for 3 weeks' time to obtain the necessary instructions and to file the counter affidavit on behalf of the respondent number 1 to 7.
Lordship.
The prayer is not objected to by Mr.
Dr. M.
Learned Counsel for the petition, who is in attendance. Raise the case after 3 weeks.
May it please the Lordship, my lord, I appear for the respondent number 8, my lord, therein, in this case, item 11. May I pray for a fixed date, my lord, on 4th of November, as I'm an outstation counsel.
Lordship, I'm praying for respondent number 9 and 10.
Item number 11.
Yes, my lord.
Item number 11.
Yes, my lord.
Okay, you are there.
I'm for respondent 9 and 10.
Sir C.D. Rumsang,
For
Learned
respondent
Counsel for the respondent number
9 and 10. Lordship.
9 and 10, and Mr. N. Burwa.
Yes, my lord. Respondent number 8, IOCL.
8. Agar likhi di.
May I pray fixed date, my lord, on 4th of November.
As sought for by the Learned Counsel for the parties, raise the case on 4/11.
Obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 7 on behalf of my senior Senti, my Lordship. Lordship, I pray that this matter may kindly be listed after 3 weeks.
The prayer is made on behalf of Mr. Sentia and Learned Counsel for the petitioner. Urge to list the case after 2 weeks.
3 weeks, Your
3
Lordship.
weeks. Mr. I. Imchen. Learned Imson. Learned senior government
Additional-
additional for the state respondents are present. Is present.
Lordship, there's an interim.
The prayer is allowed, list the case after 3 weeks. The interim order, even check shall continue till the next date of listing.
Lordship, I also beg to mention item number 24. Lordship, this matter may kindly be listed after 2 weeks, Your Lordship.
Okay. Same, the prayer is made on behalf of Mr. Sentianga,
Yes, Your Lordship.
Learned Counsel for the petition to list the case after 2 weeks.
Yes, Your Lordship.
It is submitted that you have informed the other side.
Yes, Your Lordship. I have taken the consent.
It is submitted that consent has been taken from the Learned Counsel for the other sides to make the prayer. The prayer is allowed, is the case of the chiefs.
Lordship, there's an interim.
The interim order. Continue.
Deeply approach.
May it please, Your Lordship. I beg to mention item number 21 and 22. Kindly
MS
let the matter-
Sushinu, Learned
Yes, ma'am.
Counsel for the petitioners is present. Petitioner is present. MS S. Chang, Learned Junior Government Advocate.
She's up for the
Private respondent. Yes.
Learned Counsel appearing for respondent number.
In WPC 50, I'm for respondent 8, and in WPC 204, I'm for respondent 9.
For the respondent number 4 in item 21 and respondent number 9 in item 22.
Kindly
Has
let the
made a
matter
prayer for
3 weeks. time.
adjournment of the cases for 3 weeks.
Bless
You were there.
Yes.
MSP Supreme and additional advocate general Nagaland for the state respondents is in attendance. As the prayer is not opposed to by the learned counsel for the other sides, these the cases after 3 weeks. May date to be fixed by the office.
May I please, Your Lordship? My lord, I beg to mention hearing item number 23.
Yes.
My lord, here the counsel for the petitioner, I Lematushi, is indisposed. So kindly list the matter after 2 weeks.
MS Swenson,
Mr. Crisinho.
learned counsel representing I Limatusi,
Yes, my lord.
learned counsel for the petitioners, has made a prayer for adjournment on the ground that MS Limatusi is indisposed. Full stop.
My lord, there's
Mr.
an interim.
Mr. So-and-so, learned state counsel for the respondents, state respondents is in attendance. As sought for, is the case after 3 weeks.
Yes, my lord. My lord, there's an interim.
Continue.
Obligement.
May I please, my lord? Lordship, I beg to mention item number 10 on behalf of my colleague, Kiangami, Your Lordship. Lordship, if may kindly grant 2 weeks time to file the additional affidavit, Your Lordship.
Mr. Anna Angami,
Lordship.
learned state counsel appearing for Mr.
Kiangami, Your Lordship.
Kianga,
Lordship.
learned state counsel has sought listing of the case after 2 weeks.
My lord.
In order to file an additional affidavit on behalf of the state respondents. Mr. Supanuti Ali, learned counsel for the petitioner, is in attendance and has no objection to the state prayer. The prayer made on behalf of the state respondents is allowed. Is the case after 2 weeks for filing of additional.
Lordship. Deeply obliged.
Well, please, Lordship, I beg to mention admission item 12. Lordship, if this matter can be refixed again on 18th of October.
On the prayer of Mr. Supanuti Wali, learned counsel for the petition, and as agreed to by MS Rahul, learned state counsel for the respondents. This is the case of 18.
Obliged.
I believe, Your Lordship, I'd like to mention item number 27. Let the matter come up to 2 weeks.
Mr.
Naksaya,
You are for the respondent.
private respondent number 4 to 13.
13. Mr. So-and-so learned counsel for the respondent of 4 to 13 has made a prayer for has made a prayer for adjournment. For 3 weeks.
2 weeks.
2 weeks.
No objection, Lordship.
Mr.
V. Koza, Lordship.
V.
Koza,
learned
Lordship.
counsel for the petitions. Is present and has not objected to the said prayer. The prayer is allowed, is the case after 2 weeks.
May I please, Your Lordship? Lordship, I beg to mention here in item 14 and 15, Lordship. Lordship, in item 14, I'm for the respondent number 4. And item 15, I'm for the petitioner, Lordship. I pray Your Lordship be gracious if this matter can come up after 3 weeks, Lordship.
Okay, Mr. V. Koja,
Lordship.
learned counsel for the respondent number 4.
In item 14.
And for the petitioners in 15.
Lordship.
Has made a prayer for adjournment, with the consent of the learned counsel for the other sides, including MS Lucino. With the consent of MS Lucino.
Yes, my lord.
Learned counsel for the petitioner in 14.
And for
And
respondent
for the
number.
private respondents in 15.
Yes, my lord.
For
3 weeks,
3
Lordship.
weeks. As sought for by the Mr. Koja, learned counsel, place the cases after 3 weeks.
Much obliged.
May I please, Lordship? Lordship, I beg to mention hearing item number 26. Lordship, I pray that this matter may be listed after puja break.
On the prayer of Mr.
Isukaji, Lordship.
Nisuga,
Yes, Lordship.
CC,
Yes, Lordship.
learned counsel for the petitioner. And as agreed to by MS P. Jimomi,
Z, Lordship.
JG, Learned Counsel for the private respondent.
Yes, Lordship.
Leaves the case after 2 weeks,
After 3 weeks, Lordship.
3 weeks.
Lordship.
Obliged,
Obliged,
Lordship.
Lordship, I beg to mention item 31, Your Lordship. I'm for respondent number 7. Lordship may kindly grant 3 weeks time, Your Lordship.
File 31, it is in hearing.
Yes,
You
Your
want what, to file counter affidavit?
No, Your Lordship.
Okay. MS,
Ali Dosu, appearing on behalf of Wadi Jamir.
Learned Counsel for the petitioner.
I'm for the
State
state,
Counsel?
Lordship. I'm for the
Anybody,
state,
you are for the state.
Lordship.
MS,
Bichano.
Pichala, Learned Counsel for the state respondents are present. MS, your name,
Nancy Lota.
Nancy Lotha, Learned Counsel for the respondent number 7 has paid for and is granted, has paid for an adjournment. Post of as sought for and as agreed to. Release the case after 2 weeks.
Like Your Lordship.
As sought for by the Learned Counsel for the petitioner and as agreed to by the Learned Counsel for the other states.
May I please, Lordship? Lordship, I beg to mention hearing item number 28, 29, 30 on behalf of Inaholi. Lordship, if this matter will come up after 2 weeks.
Objection, Madam. Mr. Crisino.
Okay, Christian. Learned Counsel for the petitioners is present. MS Pichal,
Lordship.
Learned Junior Government Advocate.
Lordship.
Your Junior Government Advocate.
Lordship. Lordship.
Appearing for MS
Inaholi.
Inaholi. She is Senior Government Advocate.
Junior Lordship.
She is Senior Government Advocate.
Junior Lordship.
Junior Government Advocate. For the state respondents has made a prayer for adjournment of the cases. Or as sought for by the Learned State Council and as agreed to by the Learned Council for the petitioner is the cases after 3 weeks.
Are you ready?
May I please, Your Lordship? Lordship, I beg to mention hearing item 34 and 33 and 34. Lordship, I pray that let the matter be passed over for a day.
Okay, under prayer of the Learned Council for the petitioner. Your name? The prayer of?
Indy Chang, appearing on behalf of my senior, Mojamir.
On the prayer of Mr. Swainso, Learned Council representing Mr. Muajami, Learned Council for the petition, the cases are passed over for the day. MSI Chang, Learned State Council for the state respondents is in attendance.
May I please, Your Lordship?
Yes.
I beg to mention item number 13, Lordship, on behalf of Ajungli Lordship. So kindly grant me 3 weeks time to file my counter, Lordship.
Mr.
Dr. M.
President, Learned Council for petition is present. A prayer is made by MSS Chang, Learned State Junior Government Advocate representing
Ajungli Lordship.
Atongli.
Ajungli.
Atongli, Learned State Council. To list the case after
3 weeks, Lordship.
3 weeks. You file affidavit
Lordship, we have not filed, Lordship.
for filing of counter affidavit by the state respondents.
Lordship. Mother, much
Praise the
obliged.
Lord, is the case of the case.
Obliged.
Deputy.
For motion, item number 1.
Please, my lord. My lord, the petitioners are before this honorable court seeking for parity in the scale of pay, lordship. The petitioners are, lordship, all appointed as temporary warders, lordship, under rule 177 of Assam Jail Rule, lordship. And their appointments are between 2004 and 2022, lordship. In the first writ petition, there are 152 petitioners before this honorable court, lordship. And
You
lordship,
already granted
scale of
minimum
pay.
scale.
Yes, minimum scale of pay.
Now what is your prayer?
My grievances is that, my lord, the minimum scale of pay for the temporary warders were fixed in the year 1999. And whereas for the regular employees, they are enjoying the minimum scale of pay for the regular warders is revised as per 2017, Lordship, in 2017, Lordship. So there's a difference in the pay structure, Lordship. If I may take you to the pay structure, Lordship. Page 201, Lordship. This was provided through RTI, Lordship. Page 201. 200 is the annexure. F1, Lordship. And in page 201, under column number 2, Lordship, this is a detailed statement of pay structure of regular water and temporary waters, Lordship. So here, Lordship, the net total for the regular water is 28,307. And here on top, Lordship, you can see regular water base structure level 3, ROP 17, Lordship. Whereas for the temporary waters, Lordship, ROP 1999, 1999, and the net total is 21852, Lordship. So there is a disparity. So we are aggrieved by that, Lordship. Lordship, if I may take to one annexure, Lordship. Annexure C, Lordship, page 196, Lordship. So this is the administrative approval for utilizing the services of the temporary waters, Lordship. Now, the administrative approved strength is 804 temporary waters, in addition to the 344 sanctioned posts. My Lord may kindly appreciate that in the entire state, there are around 11 district jails, including the central jail and the headquarters, Lordship. Now, this temporary waters and the those waters who are holding sanction posts, they are being deputed in various jails, Lordship, and they are functioning and they are discharging their duties exactly the same way, Lordship. Lordship, in order for me to, since the onus is on me, Lordship, I would like to take you to the page number 198, Lordship. Page number 198, annexure E, Lordship. This is the trade-wise category of temporary waters, Lordship. So now their services are being utilized as per the chart provided by the department, Lordship. Now custodial duties number is 571 waters. Office assistants is 48. Computer operators 28. Medical attendants 13. Drivers 33. Tailoring instructors 3. Barbers 7. Counselors 18. Office beyond 6. Sweepers 2.
Yes, MS Chan.
Lordship, let notice go, Lordship.
Heard Mr. Toshi Olonguma, Planet Council for the Petitions. And MS S. Chan, Junior Government, for all the respondents. Post of the petitioners, 152 in number, have joined together to institute the instant petition, stating that they have a common cause of action. Post of it has been projected that the petitioners were appointed as temporary stroke ad hoc warders stroke female warders under Rule 177 of the Assam Jail Rules and are designated as temporary ordinary grade EOG warders under the establishment of the Directorate of Prison and are posted at different jails. Posted at District Jail Dimapur and District Jail Kohima after being appointed during the period from 2004 to 2022. So one of the demands of the petitioner is that they are similarly situated with the regular workers and are discharging same nature of duties and functions. Yet they are not paid at par with the regular warders in the departments. Full stop. It is stated that the petitioners are currently enjoying the minimum pay scale of under the revision of pay rules 1999, whereas the pay scale of the regular warders are being revised from time to time, with the latest being the revision of pay rules 2007.
Yes, Lordship.
As a result, there is a big gap in the pay and allowances received by the petitioners from the pay and allowances received by the regular warders. Also, the petitioners have also sought a direction to the state respondents to act on a communication dated
25th.
25/11/2022. Annexer
Annexure J, Lordship, page
Annexer
230.
J, made by the Department of
Directorate of Prisons, Lordship, Nagaland.
made by the Directorate of Prisons, Nagaland, to the Home Department, Nagaland. So, the matter would require consideration, issue notice returnable in 4 weeks as MS has appeared accepted.
My lord, I have
Copies 2 working days.
my lord, I have a simple interim prayer, Lordship, because
What?
the petitioners have reasons to believe that the department is appointing without undergoing due process of law, Lordship. So maybe, Lordship,
Prayer for
there are 30 vacancies,
prayer for interim relief will be considered on the interim.
Lordship.
Previous appointment, what are you right? You have ad hoc.
Yes, Lordship. But then, Lordship, now,
We'll examine that. You should not be discontinued. If you discontinue, then okay, we'll see.
in that alternatively, if my lord, if the interim direction to not to disturb the services of the petitioner may be extended till the
You
next.
were serving from 2004.
Yes,
Who is
Lordship.
who is going to disturb?
In case, Lordship, because
We'll keep it for consideration on the return. Don't act, MS Chan. Yes. Next is yours.
yes, Lordship. This is a patch of
Same,
yes, Sam,
same.
in all the districts, Lordship.
Okay. District jail, same.
Districtual is different. This
In different district jails. Just make it different district jails.
yes,
Different district jails.
yes, Lordship.
135. Total 135.
No, Lordship.
In the next petition,
Oh, yes, Lordship, 135 plus.
and thereafter 160.
160, Lordship.
Thereafter
106,
106.
Lordship.
Thereafter 141.
Yes, Lordship.
Same in different jails in the state of Nagaland.
Yes, Lordship. As well as prison headquarters, Lordship.
And region headquarters.
Yes, Lordship. Obliged, Lordship.
For admission, item number 6.
Yes, sir.
Lordship.
My lord, I'll take about 15 to 20 minutes. I will not take, just make some pointed submissions. Lordship,
This holiday, I am trying to getting myself convinced whether
yes. Only Lordship,
despite my intentions,
yes, my lord,
I am not still.
my lord, yes,
Well,
my lord, yes. Lordship,
I am very frank to you.
yes, my lord. Lordship, yes. My lord, the other day, Lordship has fairly give a opinion that how to navigate the issue in view of the legal issues, in view of the peculiar facts and circumstances. Only on that point. My lord, I'll make, kindly allow me to make few pointed submissions. Yes, I sincerely hope and pray that my GPS works. Now, my lord, first submission, that the expert committee did not examine and determine the direction of this honorable court in paragraph 25 of the judgment of the division bench. One, kindly allow me to read that paragraph, page 28 to the contempt petition, my lord. My lord, to save time, I can skip the first portion, and I can read at page paragraph 29. May I read from the fourth line at page 29. Further, on promotion, you were given NCO ranks, allowances.
1 minute. Page 20.
My lord, page 28 is of the contempt petition is paragraph 25. But to save time, my lord, I'm reading next page. My lord, I am reading paragraph 1, 2, 3, 4, fifth line from the top. Subsequently, the monthly honorariums of the VGs have been enhanced from 1,500 to 3,000 with effect from such and such. It is further noticed that the state government in the Home Department, Police Branch, via communication dated 35/2016, had written to the ministry proposing the enhancement of wages and honorarium from 15 to 100 by incorporating a justification that the duties performed by the VGs were on revision and enhancement. That portion. So, my lord, this letter was also submitted, copy of this letter the other day I have submitted before your lordship. So, my lord, the division bench have given a finding that incorporating a justification that the duties performed by the VGs were on revision and enhancement. So, my lord, there is an indication by the learned division bench that the revision warrants, that the enhancement revision of wages increase warrants revision and enhancement. So my respectful submission, number one, lordship, because my lord, operative paragraph of the learned division bench starts from paragraph 24. If lordship, you can see paragraph 24, from paragraph 24, page 28, the operative paragraph starts. So, my lord, that is my first submission, that paragraph 25 of the direction of the division bench was not examined and determined by the expert committee while submitting the report. That is my first submission, my lord. Thereafter, my lord, paragraph 26 and 27 and 28, the Honorable Division Bench has discussed certain judgments of the Honorable Supreme Court. Then paragraph 29, further some directions were given. So my respectful submission, my first submission, lordship, the expert committee did not examine and determine the direction of the Honorable Division Bench in paragraph 25. That is what I'm trying to make. Secondly, lordship, my lord, because the matter has been extensively discussed the other day, lordship, on the issue of entitlement of minimum wages Lordship, the other day, I have, in my reply affidavit, a letter submitted by the commissioner. I'll bring it. Because, my lord, I'll show from the records. I'll show from all the export committee deliberations that the minimum wages was a consideration before the export committee. And on 7th of June 2020.
Where is that communication 30/05/2016?
My lord, a copy is before your lordship. Type copy, the first day I have given.
So many papers.
Yes, the first day I have given a paper. Type.
So many
Yes.
papers, it is difficult. Let me find out.
Yes.
30.
My lord, if a piece of paper which is typed, a typed copy is also enclosed.
Whether this letter is taken into consideration
Yes, my lord,
at the expert committee.
my lord, the record does not indicate that this letter was taken into consideration by the expert committee. That is why I'm making a specific submission.
Finally, what is your honor again?
3,000.
So this was the view as far back as in the year 2016.
Yes. And
We are in 2024.
yes,
But this is the view of the state government as far back as in the year 2016.
exactly. And lordship,
And
the
this is taken into consideration by the division.
exactly. So because lordship, you can see the word by incorporating a justification that the duties performed by the VGs warrant revision and enhancement. 4th line from the top. So my respectful submission, paragraph 25. The observation and direction of the division bench in paragraph 25 was not taken into consideration by the expert committee. That is my first submission, lordship. Because lordship, the learned division bench has admitted the fact that there are justifications for warranting revision and enhancement. That is what the learned division bench indicates in paragraph 25.
Now, just a minute, do you have the decision that consideration, direction, petition can be disposed of in 2 ways.
Lordship.
One is by making a direction to consider simplicity.
Yes.
And the second one is direction to consider with the observations made
My lord,
by the court.
my lord, the issue is this.
So here,
Yes.
here in paragraph 25, the division bench has considered the matter of enhancement of honorarium
Yes.
for the village guard on the basis of this letter.
And came to a finding that there is justification.
There is justification. State government also.
Yes.
And whether this, yes, Mr. Jami, whether this fact is taken into consideration. 2016, 5,000. It means in 2024,
Should be more.
more.
In my respectful
Still
submission,
you have come up with that 3,000 is enough.
in my respectful submission, your lordship, in para 25, your lordship, subject to your lordship's satisfaction, it is not an observation of the learned DB, but it is just referred to the proposal. And if your lordship may kindly see para 29, the operative portion, we have to take into consideration para 39 of Garakshak and nothing has been mentioned regarding taking into consideration by the expert committee, the letter dated 35/2016, your lordship. Specific direction was there to examine and consider in the light of para 39 of Garakshak, your lordship. So accordingly, that was done, your lordship. That is it. But if your lordship is of the opinion that no, this letter dated 35/2016 also needs to be taken into consideration, that is a different aspect altogether.
Lordship, you can appreciate the fact that the operative paragraph starts from paragraph 24. So 24 to 29 has to be read as a whole, not in piecemeal.
There is no inbuilt positive direction regarding it.
But look, the issue is this. The issue is this. The issue is this. The direction was to examine and determine. What is the meaning of determine? Lordship has already expressed the other day. So, my lord, whether paragraph 39 was also paragraph 25 of the judgment was also determined, examined and determined by the division, by the expert committee or not. That is the only issue. Because, my lord, ultimately it is a state government and the government of India who will decide. But, my lord, whether the expert committee should have just simply left out para 35 in the para 25 in their consideration when there's a specific observation by the learned division bench.
This has been basically, I have read again. I have read again.
Yes.
At first, last, it appears that, but it is merely a recording.
My lord, the only issue, the point issue is this, the point issue is by incorporating a justification, not just mechanically see the word, by incorporating a justification, my lord, that is recording. Then that the duties performed by the VGs were on revision and enhancement. That is not recording. That is something more. That is what I'm trying to submit.
Yes, that is, I have also seen that 35/2016 they wrote.
Yes.
Then, but when it was enhanced from 1,500 to 300, which effect from 1/4/2018.
Yes.
At a subsequent date, state government remained
my lord,
silent.
So that aspect of the matter may kindly be examined because, my lord, that is my first submission. Because, my lord, my respectful submission is that in all fairness, the expert committee should have taken into consideration paragraph 25. One. Now, my lord, my second submission. My lord, because time is the essence, so I'm.
No, I'm trying to find your case within
Yes.
the contempt jurisdiction.
Yes.
That is what the difficulty
Yes.
I'm facing.
So the question is, my lord, the question is in contempt jurisdiction. When there is, because lordship may kindly consider paragraph 25 should be read in the line of direction in paragraph 29. When the court said examine and determine, that means the expert committee should have examined and determined the observations and opinions given by the learned division bench in paragraph 25. That is not done. That is what I'm trying to say. Subject to what?
I said that consideration, direction to consider, simpliciter.
Yes.
And direction to consider in the light of the observations made above are two distinct.
That is why.
Direction. Here, it is the first one. Consider
No, my lord.
simpliciter.
My lord.
This observation was
My lord,
not
the question is this.
Direction.
The question is this. The question is in my respectful submission. It comes within the next category, is the second category, because in paragraph 29, it is not the word use is not direct to consider, but the word use was direct, examine and determine. It is in the affirmative. Lordship mechanism para 29.
See, I've been reading it.
In view of the paragraph 29, 2 lines, and in that view of the matter. So, my lord, when you say in that view of the matter, it is inclusive of paragraph 25. We direct the state government to constitute an expert committee to examine and determine the payments and entitlements of the financial benefits in consultation with Minister of Home Affairs. So, in that view of the matter, so the observation given in paragraph 25 is included here. And we direct the state government to constitute to examine and determine. That is, my lord, that is my respectful submission. I cannot go beyond the wording.
Because before 29, in paragraph 28, last part, the division has left it to the expert body.
Then, lordship.
That is the difficulty.
But then,
All
lordship,
this have been recorded.
then, lordship, may kindly allow me to read. From which? Then, the committee, the last paragraph, the last page. My lord, the committee
Of the judgment.
of the judgment, paragraph 29, the last page. Certified copy of this order, and the committee should complete the process of examining the enhancement of the committee should
Examine the matter of enhancement.
the matter of the committee should complete the process of examining the matter of enhancement of the honorarium and other allowances of wages as within a period of 4 months. So the committee should complete the process of examining the matter of enhancement and honorarium and other allowances. The committee should consider the enhancement. So, my lord, it is not about consideration, but it is in the affirmative. That is what I'm saying all along. The committee should examine the matter of enhancement. The matter is about enhancement, nothing more, nothing less. I'm not trying to put words into the judgment, lordship, but this is what the division bench judgment said. The committee should examine the matter of enhancement. The specific enhancement of the honorarium. The committee should examine. It is not the committee may. It is shall should, lordship. I'm not good in English, but my understanding is that.
I am also not good at English,
My lord,
but still I am not very much.
my lord, that aspect, lordship may give a serious thought. One,
I am giving serious thought
yes.
to it from the very moment I
Yes.
have taken. We are
But
conscious. We are
my
con-
respectful submission, my lord, subject to ultimately subject to what lordship says. My lord, the direction from paragraph 24 or 29 is in the affirmative. That is what I'm trying to do.
not finding any. We are trying to find out, but not
Then lordship may kindly allow me to read.
getting that lever.
Then lordship may kindly allow 4 months. Then lordship may kindly allow me to read. While considering the matter of enhancement of the honorarium and other allowances as directed herein above. So the division bench is still talking about well considering the matter of enhancement of honorarium and other allowances as directed herein above. So the word directed is given here again. So direction is for the enhancement. So lordship may kindly see that the committee should complete the process of examining the matter of enhancement, that is first, well considering the matter of enhancement of the honorariums and other allowances as directed herein above. So the first paragraph above is reiterated is the direction. My lord, I thought in my respectful submission, there is no confusion because as directed above.
Before that, ultimately, we have found, to my subject to correction, before paragraph 29,
Yes.
the division bench left the entire matter to the wisdom of the expert body.
Keep in mind, Lordship, paragraph 25.
That is not.
Lordship, keeping in mind that.
I am also trying to.
Because
Mr.
the
Takamasa,
issue is this.
actually, I am trying to
Madam,
find out.
yes,
in
I
wisdom,
really
but
appreciate-
still
Madam,
not
the
been able
point
to.
is this.
If I do not able to convince
Madam,
myself.
The point is this. Lordship may kindly see. The direction, the observation, the opinion of the division bench is twofold. Paragraph 25 is one. And paragraph 26, 27, and 28 is the other limb of the opinion. So, my lord, it should not be clubbed up together. That is what I'm trying to say. The division bench, the expert committee had only considered the observations given by the learned division bench in paragraph 26, 27, and 28, but left out the observation given in paragraph 25. That is what I'm trying to submit before your lordship. It should not be clubbed up together. Because, my lord, paragraph 27, 26, 27, 28 are about equal pay, equal work, and only which expert committee can take into consideration. That is one aspect of the matter. Paragraph 25 says there is justification for enhancement. Then, my lord, paragraph 29, if we read carefully, there's a direction. The word directed, as directed above is mentioned. So, my lord, that may be. So my submission is that the observation in paragraph 25 is further confirmed in paragraph 29. Because, my lord, if we read paragraph 25, 26, 27, 28 as one, then there will be confusion, but it has to be separated. It is two links. And lordship, secondly, this should be read in the light of the direction given by this, but another single bench and on 22/5/2022 at paragraph 9. Because, my lord, the expert committee was constituted on the basis of the direction of another single bench on 15/12/2022. So, my lord, the division bench judgment has to be read in tandem with the observation direction of the letter single judge in paragraph 9 of the judgment. My lord, can you allow me to read few lines?
Which order?
15/12/2022. Lordship may kindly appreciate the fact that the expert committee was constituted on the basis of 15/12/2022 in compliance with 15/12/2022. My lord, paragraph 9. May I read the last 6 lines? May I read the last 6 lines? After being constituted, lordship. May I read from there? After being constituted, the committee shall have their deliberation or deliberations and determine the benefits to be given to the petitioner in terms of the direction given in the writ petition and the writ appeal. This is a direction. My lord.
We cannot read that direction in the writ petition. It will be unjust for me to read that direction.
The point is this.
Whatever
the point is this. No appeal has been made against this. No appeal has been filed. And lordship may kindly see under what direction, under what order the expert committee was constituted. Lordship may kindly see the constitution of the expert committee and the report. The constitution of the expert committee was in compliance with this order.
Right, but but I am still, I have
But-
the right to record
My lord,
my
I'm only,
view, but this direction given in the
my lord,
writ petition is completely contrary
my
to,
lord,
by legal point of view, is
My lord,
completely contrary to
my lord,
when
the
a
question is,
order is set aside.
my lord,
And
I'll come to that. I'll come to that later. But I'm only submitting because the respondent did not file an appeal and comply with this order. That is why.
yes, constitution of the committee, new committee, okay, I am agreed, they have not applied, but I cannot by my mind, at least my legal mind cannot permit me to read that direction by the single judge is to be read by
My
the,
lord,
I cannot.
my lord. Because the three judgments which I have submitted, it says that the learned single judge can supplement the orders. So.
No, but
My lord,
supplementing order.
I have no comments. I have no comments. I'm your lordship.
You have to-
I'm only submitting the records. My lord, illegality may be there, or legally, or it may be fair, unfair. That is a different issue. But I'm only submitting the records. Nothing more, nothing less, Lord. I'm
No,
not
no,
trying to respond
Mr.
something beyond
No,
the
no,
record.
Mr. Takamasa, you are also a senior counsel.
My lord, I
So
understand.
you are not only merely an officer of the court.
But because since the respondents has acted upon it, that's why I'm only bringing to your lordship.
Acted
report.
upon, but
Yes,
the contours of their jurisdiction
but the.
to my understanding should be limited to the direction given by the,
The lordship.
had it been the direction of a single judge, the matter is quite
But look,
clear.
The issue is this, the Honorable Supreme Court, the three judgments which I have submitted, it says that a single judge can always supplement and, my lord.
This is not.
So, my lord, this is one.
This is not this.
Lordship may accept, may not accept, that is a different issue, but it is my duty to bring to your lordship notice the records. That is why. Secondly, lordship. May I go to the second point?
Yes.
Because my other side also will be, my lord, all along, my lord, all along, the issue of minimum wages was a subject matter before the expert committee. Finally, my lord, lordship, I show the letter on the 7th of June 2023, which has recommended also.
Not wages simplicity, it is honorarium.
My lord, minimum wages, well paying honorarium, you were conscious the question of entitlement of minimum wages was because, my lord, minimum wages is per entitlement per day. Now, lordship, may kindly allow me to see the show from the records. Now, my lord, the affidavit of respondent number 2, because all the records, comprehensive report, it shows to save time, kindly allow me to refer to that. When the first expert committee was held at page 1 on 3/9/2001, page 104.
Page 104 of what?
My lord, affidavit of respondent number 2, Cindy Younger. Right, copy starts from 104, lordship. The thick one, lordship. Yes, that should be the one. The thickest one. Cindy Younger, respondent number 2. Lordship is fine. Now, my lord, the first expert committee minutes type copy at 104. Lordship, second paragraph, 1, 2, 3, 4, 5, 6, 7, 8 line from the top on the principal secretary PNA department also commented on the minimum wages in the prevailing government policies and rules. Then lordship may kindly go to 105. The second paragraph. To the law department was further requested to examine the matter regarding the honorarium of the VGs vis-a-vis the minimum wages prevail in the state. Then Lordship, the second expert committee meeting is minus at 100. My Lord, next page, 106. 106. Lordship, if on it, the last paragraph. Thereafter, the representative of law and justice briefed the committee in quoting the reference to para 39 of the such and such duty allowances on a bar with one day wages of the police. He further elaborated on the concept of living wages in reference to the provision of 43 of the Constitution of India, such and such. He also highlighted on the honorarium vis-a-vis the minimum wages act prevalent in the state of Nagaland with reference to section such and such of the Minimum Wages Act of 1948. The next page, Lordship, 107, the third paragraph. May I read?
Yes.
Then Mother 107, paragraph, page, the next page.
Yes.
Lordship, the third paragraph.
Yes.
The representative of the finance, Lordship is found it. The representatives of the finance department opine that as per the duties, wages should be paid your duty allowances, keeping in view equal pay for equal work to the extent possible. Then, my lord, so this is in the deliberation of the first three expert committee. Then, Lordship, my affidavit in reply to
Where is the final one?
My lord, the final one is page 97, which is at paragraph, same paragraph, same affidavit at page 97 is the final report.
Report.
Yes. Lordship on it. Then Lordship can you go to 99. The 5C. Lordship, may I read paragraph 9?
Let me read it just. D7.
Yes. One of the operative paragraphs is 5 findings and discussion is paragraph 5. 5A, B, C, and D, and E, but I'll focus on paragraph 5C at page 99.
Page 99.
99. C, Mayor, my lord. The House also deliberated on the issue with reference to such and such pertaining to duty allowances on a bar with one day wages of the police on the concept of living wages with reference to provisions of Article 43 of the Constitution of such and such, and the honorarium vis-a-vis minimum wages prevalent in the Nagaland state. So all along, my lord, from the first report till the final report, 4th July 2023, issue of entitlement under the minimum wages was a subject matter before the expert committee. That is what I'm trying to highlight, Lordship. Then, Lordship, to substantiate this point, Lordship, in my affidavit in reply to the affidavit in opposition of respondent number 2, the other day I highlighted a letter.
Mr. Jamir, says that affidavit, same affidavit,
His affidavit,
99, page 99,
Lordship,
paragraph C,
Lordship,
from bottom,
Lordship,
7 line.
Lordship. In view of differences.
It was agreed upon that since the honorarium of the VGs, village guards,
Lordship.
at present are being paid out of the state-related expenditure,
Yes.
and that the Government of India, Ministry of Home Affairs,
Lordship.
had expressed inability to enhance the honorarium by letter dated
Lordship.
14/12/2021,
Lordship.
which was also reiterated
Lordship.
during the meeting on 19/5/2023.
Lordship.
The House was of the opinion that enhancement of honorarium as demanded by the VGs
Lordship.
is not feasible at this juncture.
Lordship.
What is meant by feasible?
Now here, Lordship.
What is the meaning of feasible?
Because since the, and whatever.
This is not arriving at a determination. Feasible, let us, I'm very weak in English.
No, Lordship. Even in the final report.
Feasible means
What
not
has been-
practicable or not possible kind of thing.
At this juncture, that is.
At this juncture.
At-
At this juncture is end of the matter.
Yes, yes, that
But
is, that.
Everything is influenced, appears to have been influenced by this. It is not feasible. Because just because we don't want to pay.
Paragraph 5, A, B, C, D, whatever.
Feasible.
These are what has been deliberated in the meeting. And after that, the.
No, then I have seen the 101 also.
Lordship.
They have specifically given stress,
Lordship.
especially that of the Ministry of Home Affairs, Government of India, which pays the honorarium. They are, what is in their mind that it is Government of India who pays the money, which pays the honorarium of the VGs, wherein they stated their regret, which has been reproduced at length in the following paragraph. This paragraph.
Lord.
The committee reiterates the views that increase of the honorarium at this juncture is not recommended.
Lord. Because.
Where is that?
In the.
Where is that minds of the expert committee?
In the committee, Your Lordship, there's also a representative from the MHA, Your Lordship.
Possible and practical. Too easily or conveniently. So there will be stress on the budget of the Ministry of Home Affairs. And
That is the stand of the representative from the MHA, Your Lordship. Because MHA, the representative rejected the letter which was sent. Because as I've said, the letter, why the letter, Your Lordship? Because in the first meeting, the first expert committee, 3 meetings were held, Your Lordship. But because of, due to COVID pandemic.
this appears to be not the independent mind of the expert committee.
Exactly.
This not feasible. They are not to determine feasible, possible or not possible to pay. They have to arrive at an opinion.
No.
What should be the proper honorarium. They are not going to pay from their pocket.
Lordship.
Ministry of Home Affairs, their duty is later when the proposal is to be forwarded to them. No, we reject. End of the matter. Another repetition. But here, ministry has said and reiterated that not possible, it will be a stress on our budget.
By the representative.
But where is the arrival as an expert body with your own independent mind that this should be the proper honorarium? Because come back to the division benches.
Lordship.
Examine and determine.
Lordship.
Right. Thereafter, they will forward it to the state government or central government and necessary steps
Lordship.
by the central government. They may discard it, throw it in the dustbin.
Lordship.
But where is the expression of independent mind?
And Lordship, we kindly appreciate this fact. Sorry. Subject to your Lordship.
No, but,
satisfaction, your Lordship.
Satisfaction means this is a bit. There are.
In my respectful submission, your Lordship. The other day, your Lordship has referred to Oxford Dictionary, your Lordship, so far as determination is concerned, Lordship. If my Lord may kindly see, I have the extract from Black Law Dictionary, your Lordship. Determination means something you settled it. Settled. Let's take a final decision. So examine and take a final decision. That is the, and if your Lordship may rightly point out para 28, because this is a matter which has been left to the expert committee to determine.
Absolutely.
So determine means to settle. Now, rightly or wrongly, the committee has examined your Lordship and the views taken by the expressed by the representative from MHA, your Lordship. He also reiterated the early letter which was written by the MHA, your Lordship. So those, everything were deliberated, which is there, whatever has been deliberated, your Lordship.
No, they express regret.
And your Lordship may kindly see in D also, whatever the representative, petitioner representative has stated, that is also recorded.
Recorded.
So whatever has been deliberated, everything was recorded. These are the deliberation. What are the matters that were deliberated? That it was after examining, it was determined, it was settled or not at this juncture. Enhancement is not possible and accordingly, but recommendation is made for a reward, grant of award, and for insurance, whatever they should.
Where is the 3,000 presently paid, recorded? In the minutes of the meeting, the 3,000.
Mother P. 5P.
See.
Fifth line from bottom.
I think Ministry of Home Affairs has also expressed an opinion. I don't know whether it is correct or not.
Yes.
If the government of Nagaland intends to increase their remuneration, it may do so from the state's own funds.
In fact, that is in the affidavit of respondent, but then it is specifically mentioned, Lordship. I'll bring it to you, Lordship.
This is what has been deliberated. But then.
So this is the view. I think Ministry of Home Affairs expressed the view that it may not be possible to enhance payment of financial benefit to the PGs. However, if the government Nagaland do so, you can free.
Yes.
So there it is not determined that 3,000 is the correct proper honorarium. What I don't know, subject to the contents of this letter, is it there?
No.
Is it there in the Ministry of Home Affairs?
Yes.
No, please tell me the words. It is very difficult to flip through.
My Lord, it was it was shown to your lordship the other day also in the judgment. it is
My
reflected.
memory is very.
5/12/2022 order. Lordship, if lordship.
Page 95, your lordship, my affidavit.
This affidavit.
Same affidavit, page 95.
Lordship, I really appreciate this fact that this letter 14/12/2022/21 was a matter of consideration before the General Single Bench on 5/12/2022. Leaving aside the paragraph about the paragraph 9 with regard to the direction given. My lord, in the preceding paragraph above, this letter was examined by the General Single Judge and rejected. That fund constraint paucity in that background.
Okay, Ministry of Home Affairs has rejected the claim on the ground that village girls cannot be treated as at par with home guards. They discharge different duties. It was on that basis their claim at par with home guard was rejected by the MHA. Then next part is that said nothing. We have increased 1,500 to 3,000, and that has placed constraint on our budget. So we do not want difficult for us to enhance the fund. Right. And wherefrom this committee has recorded that if the government of Nagaland intends to.
That is just deliberation.
My lord, affidavit of respondent number 10.
Who is responsible?
The representation of the government of India. Affidavit is fine. I'll show from there. It is categorically mentioned in.
No, throwing the buck is different thing.
Yes.
But whether government.
It is there.
Nagaland, no. See, these are two different things. Government of India saying that we do not want to enhance. If the state government wants, they do so. But throwing the bug is very easy. But whether state government by affidavits anything says to that effect.
Yes, my lord, can you allow me to refer to affidavit in opposition of respondent number 10?
What is the exact statement? Ultimately, it is the money who will pay.
That's my senior friend, that's pointed out, my lordship may come to my affidavit.
But in contempt jurisdiction, it is setting aside all the expert.
My lord, the question is, we are only seeking a direction. We are only seeking a direction to, my lord, in the light of the observation, we are only seeking a direction to the expert on committee to once again reconsider, keeping in view.
I am also trying to find out ways and means for
Yes.
the last
Now, my lord,
2 days. But Mr. Takamasa, it has to see the light of another day.
then lordship,
But I'm not very, contempt jurisdiction is very difficult. The writ jurisdiction is quite wider. It can set aside this order, throw it, this is a piece of waste paper. This expert committee meeting deliberation report is a piece of waste paper, throw it. This is in re-jurisdiction. I cannot.
my lord, the question is this. The question is-
Compliance, full
the question
compliance.
is- The question is, lordship, on that point, I have placed one
I have seen.
judgment which says, if it is partially complied, then direction will be only given, further given to fully comply. That is the only one I am praying, lordship. Sitting aside is a different issue, lordship, but if it is only partially complied, whether this honorable court can give further direction to fully comply. Now, my lord, two issues before I.
9/12, the 2022, I have read.
No,
I have read and
no,
read.
my lord. My lord, the letter which was submitted. In my affidavit in reply. To respondent number 2. On 7th of June 2023, lordship has kindly invite proposal for enhancement of village cards honorarium. This is written by the Office of the Commissioner who is the ex-officio Commandant General. It was submitted on 7th of June 2023. In inviting a reference to the subject cited above, I am directed to forward a proposal for enhancement of VG's honorarium. This is for your kind information and further necessary action, please. Then the proposals, my lord, either to take 5,280 or 7,500. That was the proposal. My lord, it is dated 7 June 2023. So, my lord, when the expert committee sat on 4/7/2024, this proposal was on the table. Now, the same officers who had proposed have rejected rejected his own proposal. So, my lord, whether the expert committee and in fact the law secretary, pioneer secretary, finance secretary who had recommended on this line also, my lord, changed their mind. So that aspect of the matter, whether it is fair on them, whether it is expected of them to blow hard and goal on the issue, that is serious concern. Then, lordship, on the issue of dissenting opinion, my lord, in my affidavit in reply, in my additional affidavit, which I have submitted on, my lord, on my additional affidavit submitted as permitted by the order dated 12/5/2022, my lord, I have submitted a representation. May I read, lordship? The representation says, my lord, in view of the above facts and circumstances, your humble petitioner humbly pray that your esteemed authority may kindly reconsider and review the proposed recommendations with regard to increase in the honorarium of the village cards and recommend for the enhancement for the ends of justice. In the event the expert committee declined to consider my humble prayer, your humble petitioner shall have no other option but to respectfully express my dissent by not appending my signature in the proposed final report. In the event the report is to be submitted to the higher authority without considering my prayer, my dissenting view may kindly be included as part of the report for the ends of justice. This was submitted by the president, who is a member of the committee.
Oh, he prepared a report without recording my signature. He is himself.
Then, my lord, two issues. He says, you have prepared the report without my signature, and in the event you decided to go ahead, allow me to submit my dissenting opinion.
But he is not, the committee is not bound by such.
My lord, the issue is this.
Because recommendation is made. Now the recommendation made by the committee shall be
My
forwarded.
lord, he's a member of the expert committee. The president is an expert of the committee. He represents all the VGs, 9,500. So, my lord, if the report goes along with the dissenting opinion, then lordship has really expressed. Sometimes the dissenting opinion become the law in due course. So, by not incorporating, not giving me the opportunity of including the dissenting opinion in the report, when I have submitted a specific prayer, whether my right for negotiation with the higher authority has been denied to me. Because, my lord, it's a wage negotiation, honorarium negotiations. It will go. So, my lord, the issue of negotiation with the employer is always there. So, once the report goes with a dissenting opinion, then I can always approach the higher authority and request that my dissenting opinion be considered before the higher authority. That opportunity should have been given, my lord. Now, my lord, the issue is this. Now, if the whole matter is closed, then what happens? My lord, whether the petitioner will have any opportunity to file on the question of fresh course of action, my lord, whether we can go on challenging the opinion of expert committee, and all this issue will be there.
No, I have said.
Yes. And in fact, yes.
It's not that he will not keep and fight other things. But I am not very much convinced. I am trying to find out the ways and means, but I'm not still convincing myself. That is what I have
Lordship, yes.
And so that I am keeping a door.
So, my lord,
Argue the matter.
my lord, the aspect
I'm
of,
not closing it.
my lord, the aspect of the minimum wages and recommendations, not by the same expert committee member, and he rejected his own, that may be considered. The issue of dissenting opinion may be taken into consideration because, Lord, and the issue of fresh course of action, lordship, Honorable Supreme Court is for, my lord, waiters to all these issues. If necessary, I'll place a judgment.
At D, something is recorded.
Yes.
At D, something is recorded. Page 99.
Yes.
Their claim is at par with the home guards. That is
Yes.
recorded.
My lord, my respectful submission. This is only an opinion expressed. This is a discussion. A, B, and C, B, and C, and D are discussions. But, my lord, my respectful submission is, after the recommendation, my dissenting opinion should come. Dissenting opinion should be, lordship, that I respectfully disagree and I recommend for enhancement. That is what I'm saying, lordship. Lordship is well aware how a dissenting judgment is passed. So in the light of D, opportunity should have been given to me so that I also make my own recommendation, dissenting recommendation.
No, it went on in E.
is a different issue, Lordship.
Manipur wala.
That is about Manipur, my lord. F. Lordship may kindly see the recommendation of the expert committee had also included the recommendation made by the previous expert committee for consideration by the government. My lord, this is totally misplaced because, my lord, the previous experts committee report has been set aside. There has been
Many things misplaced that like a single judge operation which is wiped out. Things are that to be taking a holistic view how to do it. That is I'm quite conscious.
My lord,
I'm quite alive to your situation, but
respectful
still
submission,
quantum jurisdiction, I'm getting very
my subject to repetition.
final is my
Yes, my humble subject to what subject to repetition, my respectful submission before the honorable court is that yes, there may be partial compliance, but the direction of the learned division bench has not been fully examined, appreciated, and complied by the expert committee.
Right.
So
direction of the division bench is to recommend.
yes,
Let us put it in
Madam-
very simplistic manner first. I'm not commenting on 9/12/2022.
yes,
Because that will be not
512.
5/12. That will not be, I'm not making it.
Lordship, yes,
Whatever we.
Lordship, fine, I accept.
But it is, since we are writing, we are not making.
I understand,
I have to see that also.
Lordship,
I have to see the law, a large picture of law also
Lordship,
at the same time.
Lordship,
I am quite aware of 5/12/2022.
Lordship.
But ultimately, it is to be recommended in
Lordship.
simplistic term. That expert committee has to recommend.
Yes,
And recommendation is not for higher honorarium. As simple as that. Very simplistic. But to find out something more and to make it make the report how to criticize legally. We need a contempt jurisdiction that is
that's why.
that is going through my mind
Why?
right from the very beginning, having alive to the situation faced by these village guards.
My respectful submission, subject to repetition. Lordship, in view of the observations and direction of the learned division bench in paragraph 25, read with paragraph 29. I will not, I will not, I'm not going.
I was trying to reconcile, but
My
what
lord, my lord, because my lord 25
had
says,
it been said,
my lord
had
25
it-
says,
had it been said that 25
25 says,
in expressly or impliedly, I could have proceeded.
my lord 25 says, 25.
I have read and read.
My lord 25, because the last three lines, no, that is one. My lord,
You might be successful in another venture, but I don't think it is successful by repeating.
yes, lordship. I agree.
I have read and
Lordship,
read
lordship,
that 25 and 29 and try to reconcile
yes,
whether it is implicit there, right?
lordship,
Am I audible?
yes, yes. My only respectful
Am
submission.
I audible? So I'm trying to find out whether 25 is implicit in 29.
My lord, the
I have read.
my lord, my respectful subject to repetition is the second paragraph's second limb of submission of paragraph 29. My lord would say that us, well, considering the matter of enhancement of honorarium and other allowances as directed here.
Yes,
That's all.
I have read it 5 times. Mr. I am alive. That is why I'm.
My lord, that is all. And the other issue, so my lord, my respectful submission is, and again, that it is only partial compliance. And when it is only partial compliance, Honorable Supreme Court has already said that this Honorable Court, contempt court, have the power to give direction to the respondent for full compliance.
Expert committee was given the task very simply, without going into the all of them, that to examine and determine and recommend.
Yes.
enhance competition.
Yes.
And expert committee has recommended no enhanced competition,
Yes.
ultimately. While arriving at the deliberations were there,
Yes.
and those deliberations may be deficient
Yes.
to whether those are to be looked at in contempt jurisdiction, despite 5/12/2020.
My respectful submission is,
From my end, it is.
my respectful submission is yes. My lord, whether in letter and spirit it is complied or not.
I think you should keep it alive. Otherwise, the answer is, from my side, is difficult to express.
I'll leave it to your lordship then.
I'm here to you. I'm alive to the situation faced by the home guards. 3,000 is quite bigger in the present day context, quite meager, completely unjust. But in the contours of contempt jurisdiction, had it been a writ jurisdiction, yes, some kind of positive direction should have been there by the division bench. There is no positive direction. This is my view. Everything has been left to the expert body without any kind of positive direction. As directed above means what is contained in page 29. This is my understanding. Had it been related to 25, I would have entered into.
My respectful submission.
That is what
My respectful submission is subject to repetition. The findings of the learned division bench starts from paragraph 24. So when as directed above, when he is mentioning my respectful subject to what lordship says, it is inclusive of the observations and direct observations and findings given from paragraph 24 to 29. You can't divide that because lordship we can see from paragraph 24 onwards. That is the operative portion. So how can we read in piecemeal? How can we read the direction of the? It has
But
to read
at the last portion of paragraph 21, it left everything to the wisdom of the expert body. That is what the difficulty is. The division bench at the last part of paragraph 28 had left everything to the wisdom of the expert body without any kind of positive direction.
My respectful submission is the findings of division bench is two limbs. Paragraph 25 is one limb, 26 to 28 is another limb.
I know in my mind there are decisions, what is consideration, that appears to be not positive direction. Mr. Takamasa, I am trying to find out ways and means, but not getting convinced. To give any kind of direction to deliberate on the matter again, as on did at this juncture, according to expert body. According to expert body's view, at this juncture. Yes, what to do? Can we put it after vacation?
Lordship, if that is so, fine. I'll try my luck. Right after vacation, I then give it because we cannot. It is not necessary to keep. It is a complaint of 2022. My lord K. Sema cannot take up this matter because it was the council there in the.
Who? Oh, this is Sema.
Sema cannot take up, but the other bench would be available. So I'll make an attempt.
I think. Naam ki record. Takamas. Senior counsel. Assisted by Iron.
Yes.
Learned counsel for the petition. Also had Mr. TV Jamil. Response number 2, Imstrong, 4 to 9. Hangtang. Available. Present or present. Of course. Do you have the roster? Do you have the roster?
But the second My lord, from next week, after the holidays also, the two judges will speak.
No, who is the other?
I don't have with me. I don't have with me now.
High school problem. Court master. Hey.
I can make an attempt in board number two, because two judges will speak.
Let me find out who is there.
Yes,
Who is there? Let me find out.
Justice, Justice Sima and Justice Budi.
Justice?
Body it will be speaking.
Okay.
So you can take up the matter. Lord.
From otherwise, I'm indicating just 411 to 1511. Both the judges, you can see.
Yeah, I've seen. I have no problem with any judges. But the earlier, because the matters keep pending for so many months, years, it's a matter of.
As the hearing could not be complete. Release the case. Any chosen date?
Lordship, any day, your lordship.
Monday. 14.
Lordship, it will be 15. 14, I have difficulties.
Okay. And 15? 15/10/2022. Matter is not to be treated as part of. Sorry, Mr. Takamasa.
It's okay, lordship.
I have also.
The lordship, I'm appearing for respondent number 1. If I can.
Already Anangami is there. Repeat, present.
Right.
I'm trying to making myself convinced, but still he's not able to because of the contempt jurisdiction. I'm still also not convinced that division bench, when after setting aside, division bench passes an order, it is a contempt jurisdiction to be vested in the single bench, in spite of the rule. I'll not convinced about this rule. Because in principal seat, contempt cases are taken up by division bench. Whenever the contempt is pertaining to each order.
Well, Lord,
And when that will pass by the single judge is set aside.
If it is set aside and if the view is of the division bench, independent of the view of the single judge, then it is the division bench there who takes up the contempt cases. Here, the rule is saying otherwise. Now, I'll show it to the Honorable Chief Justice.
yes, because here we go by the rules. We have no option. You have a point there, because whenever I came that side, I have also practiced on that way.
So I have been doing in that manner only.
Yes, I also have gone through that.
I
process.
got confused
Yes.
because it is set aside, clear set aside, without anything else. But despite that, rule says otherwise. That is, I'll convey it to the Honorable Chief Justice also. This is a disparity and the practice going on in the outlying benches because of this. You are following different practice in the principal seat.
Yes.
And different practice in permanent benches. Just
For admission, item numbers 8 and 9.
is there anything? Yes, madam. I don't think. After vacation. Is it?
I just have one submission to make.
Yes, please.
Lordship, in WPC 147, Lordship.
Hmm.
I filed my affidavit, Lordship, and so Lordship, in for WPC 167, Lordship, so I'll be relying on this 147 only, Lordship. And as per the order dated, Lordship, 4/7/2024, Lordship.
4/7.
4/7/2024, Lordship. The government was instructed to bring instruction as to why the salary was kept pending and why it was not released, Lordship. So with regard to that, Lordship, I have received one instruction today, Lordship, which if I'm allowed to.
Petitioner is one and the same or different?
Different, Lordship.
Different. Now it is, subject matter is what?
Same one, work charge regulation.
No, or regularized.
No, Your Lordship, I'm praying for minimal scale of payment regulation. Minister. So Lordship, Lordship, you kindly come to page number 2, Lordship.
Yes.
15. The petition is Akingni, Lordship. And the remarks, Lordship, can kindly come to the remarks, Lordship. Date of birth does not match in the beams and Aadhaar, Lordship. So the date of birth of the petitioner does not match in the beams and the Aadhaar, Lordship.
Now this is in respect of what? Which petition?
Petition number 147.
There you have already filed an affidavit.
Yes, Lordship.
You bring it on record then by additional affidavit.
Lordship.
Better to be on record. It will be difficult to deliberate today.
Just receive this, please.
Then they can respond. If you bring it on affidavit, then they can respond.
Lordship.
Right.
Lordship.
Heard MS,
Yes, Jillian.
Learned Counsel for the petitioners in both the petition, and MS H. Chang, Learned Junior Government Advocate for the state respondents. Also, MS Chang has submitted that an affidavit in opposition on behalf of the state respondents has already been filed in WPC number 147 and of 2022. MS Sang has further submitted that the statements and averments made in the said affidavit filed in WPC number 147 of 2022 would also cover the case of the state respondents in the writ petition, WPC number 167 of 2022. MS Sang has further submitted that she has received some additional instructions in respect of the petitioner number.
Both the petitioner.
Both.
Yes,
In respect of the two petitioners in the writ petition WPC number 147 of 2022. And she would like to bring such additional instruction by way of an additional affidavit within 2 weeks' time.
From next week.
3 weeks' time.
Lordship.
3 weeks' time. The prayer to file additional affidavit.
Lordship, we are
Additional
unable
affidavit.
to receive affidavit in opposition in WPC number 167 K of 2022, Your Lordship.
They are saying they are not filing. I have recorded. She submitted that whatever she said in the affidavit in opposition in 147 of 2022.
Your Lordship, as per the last order dated 19/9/2024, Your Lordship, 19/9/2024.
Already filed.
Here, if no affidavit is filed.
Already
on the-
filed, and she submitted that 147 affidavit will also be applicable in 167. Already I have recorded. কি করলো? Is allowed. List the case after 3 weeks. Cases.